I'm his advocate. I want to help him. I believe in his innocence. I'm not going to stand in this courtroom and do anything wrong to him at all.
Unmuting would be nice. I don't want to pull a Jake off over here.
I'd catch it before 40 minutes went through.
I've gotten the habit of looking, because I usually have myself on mute, but I've gotten really good about looking, because I don't want to do a whole show and then realize I was on mute the whole time. But then again, I pay attention to my comments. So, hey, Butterfly, thanks for joining, hun.
Hi, Butterfly. Appreciate you being here.
Yeah. We'll give it a few minutes and see if we can get anybody to come in and talk with us. A lot of filings came down in the Kohberger case. So, and that's what I've been waiting on, some juicy filings. Don't know how juicy they're I haven't looked at all of them yet on purpose. I did read through a couple. I started to, and I was like, whoa. So it's going to be interesting to review those. There's like 13 motions to suppress so far.
Yeah, that's going to be very interesting, and to hear. Well, so the state's going to offer a rebuttal for that, a written rebuttal for that, right? And then they're going to argue about it in front of the judge. So that should be interesting.
Yeah. Hey, Gina, welcome in. Yeah. So we had caught Anne has kind of, and she had also mentioned stuff like this motions to suppress will be coming, including the sheath. Well, there's not one for the sheath that I saw today, but I'm sure it will come later. These seem to be pertaining toward the very beginning, like search warrant stuff. So we're going to dive into those and see exactly what all she's trying to get suppressed, and will any of them stick? Who knows? Is it just another case of defense attorney throwing stuff against the wall, or is there validity behind these filings? Because I honestly have been waiting on them, because it's nothing in Idaho 4 that's shown me anything is weird going on, except for some fighting over discovery issues, which are valid. Those are valid things, but other than that, it's like I'm waiting on documents to tell me something here.
Yeah, and there's so much evidence that is questionable in this case, as in it's being argued back and forth in a lot of high-profile cases because we have the ancestral DNA type of thing that I believe they based their search warrant on. So they went to his house in Pennsylvania and found his.
I don't know if it's just me, but you're cutting out again. Is it me, guys, or is Joe cutting out for everyone? Is it just me? Hang on.
Test checking 1 2 3.
Yeah. What were you saying about the DNA stuff?
Well,
I was trying to hear you and you were cutting out, and I was like, wait, what?
So I thought they used ancestral DNA. They found his dad's DNA in the trash in Pennsylvania, and they used that to say that the DNA on the knife sheath was related to his dad. So it was his. I thought that was the case. And then also the cell phone data, the geofencing or geolocation. I think it was geofencing.
There was not a geofencing. No. So no geofencing stuff in Idaho yet that we've ever heard of. Lots of talk about has all the things everybody's wanting to be shown in Delphi, they're wanting to keep out in Idaho. So it's like, make up your minds. Either we like the FBI and what they can do, or we don't. So as far as they're saying that the phone data is inaccurate, and that's all great. I mean, they're going to have, they got Cyray, plus the FBI has their expert who was the one that testified in the Chad Daybell case. He's pretty darn good. I listened to Nick's whole 2-hour testimony, and you better bring it, Cyray, because he's got good answers. As far as the sheath DNA, when they got the DNA, a lot of people are confused. We did a lot of deep dives on DNA and all the things being talked about in Delphi, we've deep dove in the Idaho case, trying to figure out things in the Idaho case. So it appears what they did, or as far as we know, when they got that DNA off the sheath, it was not a complete profile there, and they got their profile. But when they went to go, my theory is they tried, more than likely. You can't be all we can't have idiot cops all across the country. So I'm going to think in my mind they were probably trying to get a DNA sample on Kohberger while he was still in Pennsylvania or in Washington, because we know from past court filings in this Idaho case, the investigators were following somebody else around and obtained a cigarette butt they threw down to get their DNA to see if it matched that sheath, and it didn't. So don't tell me they weren't trying to get Kohbergers. Now, if you live in an apartment complex and everybody throws their garbage into the community dumpster, are you going to sit out there and wait for him to go throw his bag in and see if you can get the right bag? But who knows why they couldn't get it while he was in Pennsylvania? I mean, in Idaho or Washington. Once he got to Pennsylvania, they were following him, and they were staked out documents. Is dad takes out the garbage, they see it, once it's on the trash, once it's out there, it's free game. They go and they retrieve the trash and they get male DNA, but the profile came back as Kohberger's dad, or the father to the person on the sheath. It compared to, they were thinking they were going to get Kohberger's DNA out of that garbage can, but they didn't. They got dad's instead. Then apparently in the middle of the night, they're still watching the house, and they see Kohberger, according to law enforcement now, not me, they see Kohberger leave his parents' home and walk to the neighbor's trash. And if you see the homes, they're not like right next door to each other. Oh, yours is full, drop it in mine. No, he walked down a minute to the neighbors and put trash in the bin and walked back to his parents. Well, they went and got that trash. There his DNA was in that trash, or they collected it to be tested for DNA.
So if they tested that for
Him.
DNA,
What?
if they tested that for DNA, was that a direct match to the DNA
Yes.
on the sheet?
They say it is. Yeah. Now, there's theories out there that they took dad's DNA and kind of mixed it over here, what they had on the sheath to do. I can't go down that road. Nothing that Ann's telling me is telling me that yet. I'm going to go by her lead, right? There's just too many crazy stories out there in Idaho. I'm over it. I'm over all of them. You bring the facts, or we don't go talk about it at all. But so that's what they allegedly have done, is got the dad's DNA. When they ran that DNA, and I don't know how quick they must have got it before they were watching that house, because you couldn't have obtained it and got a profile that fast. You know what I mean? It takes a little bit. So there are ways to test it in the field now. I'll test certain DNA samples in the field for a preliminative test. But so then when they got the profile from the father's garbage can, it came back as the probable father to the person on the sheath. And then when they got the garbage out of the neighbor's can, that particular DNA matched what was on the sheath allegedly. But authorities say when they went into the house to arrest him, he's standing there with his boxers on and he's got gloves on, and he's putting his personal garbage into little Ziploc bags. Now, I've heard all the theories out there. Well, you got to do that. You got to separate your trash and your recyclables and all this. Well, we all live across this country, and I don't got to put mine in Ziploc bags to recycle it. It has a whole separate can. You know what I mean? There's
Right.
no, people's like, oh, it's the homeowner association rules and all this. And people have looked into that in that particular area. No, it wasn't a rule. Hey,
DB's got a good comment on there. You might.
I just looked down and saw that he had that. They had a pin register and surveillance on BK. Yeah, they did. I think. But yeah, so there, that was about, and Ann Taylor was really wanting to know how you got back to my client. That was it that DNA tool you used, or did you find that white launcher on the WSU campus? And that was a big dilemma for her. Now she's not brought much of that back up. I'm thinking that she's a lot of this stuff she has, and she's either satisfied with, or she's coming up with a way to go after that eventually. There's a lot of things that she is saying and doing that hello woman, I never know what she's going to be calling herself this, you know what I mean? It's so funny to watch. But so yeah, it's interesting. And we knew, I guess with this new judge, she just ready to get it all out there, because he has set up deadlines, and they have, a schedule they want to follow, and to get this thing to trial. Because honestly, none of these trials should take 2 to 4 years to get to trial. You either have your evidence or you don't. You either got an expert to dispute it or you don't. I mean, it's not rocket science. A lot of it, you know what I mean? It's just, but is your client willing to sit there on a trial to start, especially if you're declaring innocence and you were just out driving around? I feel like I'd be like, man, I don't want to sit here all this time. Really? Can't we do something? So I guess we all know by now what a Frank's motion is, most of us who have followed Delphi, right? So they want to have a motion to take a look at the evidence and to make sure everything was right. And let me get down here at the case log. I wonder, though, we don't know much about this. This judge didn't preside over the Vallow case or Chad's case, so I'm not real familiar with this judge and the way he would or wouldn't rule. My take on him the other day when I watched the hearings on the death penalty, he's smart, he's listening, but he's not willing to just give them. I don't know if that's good or bad. You know what I mean? I don't want him to be like Gull in any kind of way.
Yeah, no, he was giving Anne everything that she gave him, and then some.
Well, Judge was.
No, the one in the hearing, the other
Yeah.
day. Like, I'm just talking about in their legal arguments, and it wasn't I'm not saying that in a non-legal way, like in a go way where she's just like, hey, I'm just going to rule this way, whatever the state says I'm going to rule.
Mm-hmm.
He was like, okay, you're making this legal argument, and here is my legal opposition argument to that. Like, every time she would say something, he'd be like, yeah, but if we dive deeper into this, then this is what this really says. And she'd like, well, I don't disagree with that, but
yeah,
she said that like 6 times or 10 times in that.
Oh yeah, that's Anne for you. And
Yeah.
she pushes the limits. She absolutely does. I'm telling you, this woman is a bulldog. She's not playing around. She's the top death penalty attorney in Idaho, like literally. And he was very lucky to get this attorney. He's very lucky that she other clients facing just as bad. She's got a murder client right there along with him that absolutely is guilty of what he did. It's kind of caught on tape in a lot of ways. I mean, the guy's got a really bad record. He's a horrible guy. He stood silent right beside Ann Taylor, just like Brian Kohberger did. I mean, everybody made a huge deal about that standing silent. That meant something. And apparently in Idaho, it doesn't, because Lori Vallow did the same thing. I tried to tell people that. Lori Vallow did that. What did it mean for her? It's an avenue that you take when you don't want to stand there and say not guilty. So it's for certain ways to for like appeal later and things of that nature. I got an attorney friend over on Twitter, and it's not Andrea, it's somebody else I talked to that I've been talking to for 2 years about this case, and I'm trying to butter her up to get her to come on and talk to me, but she likes her privacy, and I don't blame her. But there's just a lot of legal things that are going to be happening with this case that are not it's not niece Skylar. Oh my gosh. Yeah, I was just looking at that case yesterday. It's actually right here on the damn Idaho website thing. Skylar Mead. Really bad guy. Did some really bad things. I don't know how Anne's going to handle that case going.
So that
Sure
was
it's
the
going to
case.
do it.
That was the case where he broke out of prison and he had somebody waiting on the outside for him. And
Oh yeah.
right.
Oh yeah. And they murdered somebody. I don't know. I mean, you're going to get, when you're a public defender, you're appointed who you're appointed, but she's the death penalty attorney. So, but yeah, it just goes to show that that's like a thing with Idaho, for standing silent. It's just one of their avenues you can take in their legal process. It didn't mean anything special or outstanding for Kohberger to do it the way people thought that it did. I believe. I mean, she had her reasons for having her clients do it. I'm not going to argue against those reasons, but it wasn't special to Kohberger is what I'm saying.
Right. I kind of see standing silent at the beginning of a court proceeding, of a trial, whatever, however it goes, kind of like pleading no contest at the end.
Yeah.
Like when you
Yeah.
plead no contest, you're not saying I admit to the guilt of the crime, but I'll admit that I will likely be found guilty if we go to trial. So I'm going to just say no contest, and you sentence me accordingly.
Yeah. And that, because in Florida, we have no contest. And that's basically, it is the same thing. Yeah, woman, that Idaho's not the only state with a firing squad, by the way. The firing squad, they're not going to take Brian Kohberger out there in 30 years if he's found guilty and open a firing squad on him. I'm not going to argue death penalty with people, but the way that law reads is if they don't have the lethal injection medication or something like, that nature to carry out that form of method, then they can use a firing squad as their option. But Ann Taylor's already disputing that firing squad. It's already being disputed in other cases. And in fact, the last hearing the other day on the Kohberger stuff, all that was brought up. All of it, because but before these motions were filed, she's got, we got all kinds of motions up here to strike the death penalty on all kinds of different grounds, numerous grounds, not just one or two, but all kind, including the fact that she says it's going to cause her client anxiety to sit in jail and wonder about how am I going to die. But, she's going to fight that fight, but that's what they do. But no, it's not like that's going to be their first option, is to be like a firing squad, but it would be, I guess, their last option. So I know that they had another discovery that they tried to file. Okay, so let's start right here. Why is it not showing it to you guys? It's still showing you something different. Hang on, let me pull it up. Hang on, I got to pull it up on my other one. 1 second.
I see links on the state of Idaho Judicial Branch
Yeah.
website.
I just got to pull up my other one. That way it'll pull up what I'm showing, what I'm reading, you guys can see. Where'd it go? Let me see if it shows you now. Okay. Okay. So it looks like the defense wanted to extend a little time on something for discovery. And let me pull this up where I can read it better. Can you guys see that okay? I think I need to make this screen a little smaller and squeeze y'all down so I can make this one a little bigger.
There we go.
There we go. All right, yeah, as long as I can still see chat and everything good, I'm good over here on this other screen. Okay, so this was a defendant's motion for leave. Brian Kohberger, by enthusiasm, order governing further criminal proceedings and notice of trial settings, specifically the discovery motion deadlines of November 14th. The defense counsel and investigation team, investigators, have not finished a full review of the vast amount of discovery in this case and will continue to do so. I believe that order was denied. Joe, I just look over and read your comment. Y'all distract me.
Yeah.
So yeah, they wanted to, I guess, more time to file a couple more motions on their end, and that was denied. And let's see, let me move this out of my way so I can read my notes. I've got too many things going on my desk, and I didn't even mean to do that. So it looks like that, though, because of that reasoning, with yesterday being a deadline, if there's any more disputes not already filed, they're going to have to get special permission from the court to do so. So it would probably be a case by, or not case by case, but individual, piece by piece, if she can still get that or not. That'd be interesting to find out. I don't know what she got so late that she's not ready to file discovery on yet. I don't know. So when they applied for the Franks hearing, it doesn't tell us anything in there. There's no memorandum like we would all love to see, because I know I'd love to see it. It just says that it's a motion for a Franks hearing, comes now Brian C. Kohberger by an account for Kohberger. Amazon provided history records regarding customer email, Brian Christopher Kohberger, 1994 at gmail.com. How the agent located this was not explained. Investigators know that Amazon holds records for identifying devices the customers used to access their accounts, all linked accounts. Other items customers have searched, clicked onto, placed in the cart, and viewed. Now, see, there was a lot of that talk in one of the documents that came down. Was they were when they did search Kohberger's account, they wanted everything, not just his purchases, but what he looked at, what he viewed, what he clicked on, what all the things that he was doing with that account that would show up. Who or how the investigators know this is not explained. So are they saying that Agent Shirley nefariously looked up Kohberger's account and then they got a warrant from that? I'm not quite understanding what she's saying here. Little information about how Amazon collects and holds data was explained. The time frame, March 20th of 2022 through March 30th and November 1 of 2022 through December 6th were selected. Mr. Kohberger has a privacy interest in his Amazon.com account information protected by Article 1, Section 17 of Idaho Constitution that requires a warrant. So she's saying they obtained and looked at this information without a warrant? How would you do that? Both the Fourth Amendment, I'm not going to read all that, that involves a two-party inquiry. Did the person have a subjective expectation of privacy in the object of the challenge search? The person challenging a search has the burden of showing that he or she had a legitimate expectation of privacy. Well, I think we do, but she is literally saying they found all this out without a search warrant, and then got the dates different, like retro dated them or something. Is that what her argument is? Information shared with anyone with whom a person does not have a recognized evidentiary privilege is free for the government to take without a warrant. To put it to another way, the third-party doctrine insists as a matter of law that you should trust your secrets to no one. Ain't that the truth? Idaho has taken somewhat unclear approach to third-party doctrine. The court permitted protected health records to be provided to the government. In State versus Cluss, the court did the same for billing statements from utility companies. The court held that people had no exception of privacy in trash placed outside for pickup. However, the court has held, State versus Thompson, that under the Idaho Constitution, citizens do have a right to privacy in who they call, and later extended that to text messages. Idaho is not the only jurisdiction trouble apply it both to the search of cell phones and the use of cell sites. The issues of the United States Supreme Court seek to take the third-party doctrine in most recent decisions to seem to be the scope of the information available to the government without a warrant if one follows it closely. I was just catching up on chat real quick. I saw it moving and I looked over.
That's pretty interesting that we're talking about third-party doctrine at the U.S. Supreme Court level. Yeah.
Yeah. Didn't Kohberger have some FBI time? No. Woman, are you talking about, did he work or serve with the FBI? Is that what you're asking?
No, I think he wanted to, right? He wanted to be like some type of a super forensic investigator.
People have theorized that Kohberger was working undercover on something in Idaho, and now he's being framed. But he's not what he did do was apply for a job Danger, was it Moscow PD or was it WSU? He wanted to go to work for these rural police departments and teach them and show them the best way to collect forensic data. The very thing that has him, except for that DNA sheath. But he was denied the job. It was Pullman. That's right. Hey, Danger, I'm so glad you come in, my old friend, my favorite research partner. Yeah, so that's what that was. He did apply for a job, and there's emails out there about that actually, and it wasn't that long before all this took place, the murders and all that happened, that he applied for the job, and for some reason he was denied. Yeah, it was based on the emails that we saw that he was applying for the job over there in Pullman, with their police department, but he was denied the job. He didn't get it. It was like an internship program, to go out there and do your thing. But which is probably a blow to him because he really wanted to do it. And here he is a big deal at WSU. He's a criminology major. He's a teacher's assistant. He kind of needed that job as part of his portfolio, but I don't know what happened or why they told him no. We don't have the backstory on all that yet. Okay, let me read. Oh Lord, I just saw something about some safekeeping. I'm getting nervous. Okay. No.
We have safekeeping PTSD.
Y'all can't stick Kohberger somewhere for safekeeping because you're going to set the world on fire. He's fine. Leave him alone. Hey, he wanted to go to Ada County, him and Ann. So if it's a little louder over there, he got to get used to it. He'll be okay. He's still going to be took care of the correct way. I have no doubt about that. I don't have any qualms about his rights being.
So I just had the weirdest thought, like the irony of calling it safekeeping and knowing what Richard Allen went through when he was in quote unquote safekeeping.
Nothing safe about that, was it?
That's
Nothing
just
so
ironic. And then the judge who ordered that recusing himself shortly after. Anyway, okay.
Yeah. But he was scared of. He wasn't going into safekeeping. Shit. I can't. If I start talking about Delphi, I'm gonna start cussing and all kind of things. And the other thing I've seen the last few days, there's a full moon out there happening and all that kind of stuff. It's best I just stay away from Delphi for a moment. Idaho is not the only jurisdiction to have trouble with third-party doctrine in the United States. Okay, I think we read that. The issues the United States Supreme Court seems to take with third-party doctrine is its most recent decision seems to be the scope of the information available to the government without a warrant. Okay. In the Miller, the checking the account, where'd it go? Let me scroll down. She's going through some case laws here with different cases about the third-party doctrine. So we're not going to read through all of that, though. But that is what she is basically saying with this motion, that they obtained that warrant based on the IGG material. And if they did, they have to throw that warrant out. So this one was the motion to suppress the Amazon. Now, Danger, did you hear this part about this special agent that was looking around and found this, according to them, found this information on Kohberger? It's going to be Special Agent Shirley. You know who I'm talking about. But I don't understand why, if you're looking, say if I got your name and I go and look at I got to have your password to see your Amazon account, right? But how could they obtain any information from that account without a valid warrant? Unless she's saying Agent Shirley went in on through a back door somewhere and did his thing. Yeah, me too, Danger. Let's look at the next one that she's got out. Okay. So this is the motion to suppress and the memorandum for the defendant's apartment. Motion to suppress and memorandum in support, RE, search warrant for defendant's apartment. All eyes. Hello. Welcome in. All right. This motion and documents in support of the Franks versus Delaware. We're not going to go through that part. Issues. This court should apply Idaho's exclusionary rule and law to this search. The affidavit submitted in support for the application for the issued search warrant recklessly or intentionally omitted material information. The affidavit submitted in support of the application for the issued search warrant included information that must be excised. All information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy, and thus nothing in the warrant should remain. Remember when Anne was fighting to get everything from the FBI? I don't know, Danger, I know you do. So when FBI is only going to turn over what they want to turn over. They're not obligated to turn over a whole lot of anything. Well, she kept pushing, and she got her TUI letter done, which is you have to fill that out to get anything from the FBI that you want brought into court. She got that done. The judge gave her the subpoenas for the cast, all that stuff she was wanting. I don't know what all the FBI finally did return to her. I don't know if she got all she wanted or not, but I wonder how much she did get on this IGG from them, because there's going to be dates in there she's going to be going by to determine if they use that IGG material to obtain these warrants. You got to prove that's what they used. It's one thing to say they did, but it's one thing to prove on and on about that for 2 years. And I'm like, well, we don't know, which came first, chicken or the egg, the damn car at the WSU campus or the IGG? Did they happen around the same time? Or was there, behind the scenes, well, let's just make it look like this happened first versus this? I don't know yet until we are getting here finally. So we'll see if we can get somewhere with it. But that's what she's saying with so far from what we've read, is she's basing all this on they're getting back IGG and they're using that to obtain warrants on her client. Due to the haphazard way in which law enforcement has kept and disclosed records in this matter. What? She read the same stuff I read. The following are the facts relating to obtaining the search warrant for 1630 Northeast Valley Road, G201. This is his apartment. On December 28th, Trooper Larry, oh my Lord, I can't see y'all. Let me get this where y'all can see it better. Let me make this bigger. Okay. On December 28th, Trooper Larry of Pennsylvania State Police became aware of the objective of arresting Mr. Kohberger via the Moscow Corporal Payne. On December 29th, 2022 at 4:45 p.m., a magistrate in Pennsylvania issued a search warrant for Mr. Kohberger's person. So that was the day after. On December 29th, 2022 at 2:22 p.m., same day but a little bit earlier, the magistrate in this matter signed an arrest warrant for Mr. Kohberger. The affidavit for the warrant was signed by Moscow Police Department Corporal Brett Payne. The basic facts Payne used to support the search were: next to the body of Madison Mogan was a tan leather knife sheath. The Idaho State Lab later located a single source of male DNA on the button snap of the sheath. Footage from the King Road neighbor 1112 showed, or was it Linda Lane, showed what the suspect was. Footage from the King Road neighborhood showed what the police suspected was the vehicle of the killer. Oh, that could be either one of the Linda Lane or 1122. This white sedan lacked front license plate. A vehicle specialist decided on the footage that the vehicle was a 2011 to 2016 Hyundai Elantra. A vehicle matching that description was spotted surveillance in Pullman. It was later discovered that Mr. Kohberger drives a 2015 Hyundai Elantra, and that he lived not far from the last place a white sedan was seen driving in Pullman over an hour later. Huh? Hold on, I gotta reread that, guys, because you have to pay attention to Ann's wordings. A vehicle matching that description was spotted via surveillance in Pullman. It was later discovered that Mr. Kohberger drives a 2015 Hyundai Elantra and that he lived not far from the last place a white sedan was seen driving in Pullman over an hour later. The same specialist indicated the car seen in Pullman was a 2014 to a 2016 Hyundai Elantra. Witness Dylan Mortensen had indicated the height of the person she saw at the time of the attack is between 5'10" and 6 feet, and he had bushy eyebrows. Police determined Mr. Kohberger fit that description. Records from an August 21st, 2022 traffic stop showed Mr. Kohberger was the driver of a white 2015 Hyundai Elantra with Pennsylvania plates lacking a front plate. It also showed he had the phone number. I'm not going to read it, but there it is. He noted investigators learned that this was an AT&T number. Mr. Kohberger had changed his vehicle registration to Washington on November 18, 2022. Yes, he did, right after his birthday, or close to there. Cell tower records did not show Mr. Kohberger was in Moscow at the time of the murders. Well, his phone was turned off, so I don't know where he was. In law enforcement's experience, however, people committing crimes typically turn off their phones. And that's what they said. Now, going back, now the PCA says, according to their, knowledge as law enforcement, now and people were going on and on about Faraday bags for a long time in this case. Now they're being talked about over there in Delphi now, that's what they should do with these phones to preserve them when they get them. Turn the phone off, place it in a Faraday bag. Would a criminology student know to do that to preserve where that phone's last location was? I don't know. Made me question some things when I heard all that. Because we've been looking into all that for a long time with this case, trying to figure all this out. Because the phone was on, and then it's offline for 2 solid hours, and then it's back online. But the 2 hours, I'm assuming, is when he was driving around sightseeing and stuff in the rural area with no signal. Cell towers did not show Kohberger was in Moscow at the time of the murders. In law enforcement's experience, however, people committing crimes typically turn their phones off. Historical cell site location information, or CSLI, was obtained and given to a cellular analyst survey team, CAS, with FBI. The team determined that on November 13, 2022, at approximately 2:42 a.m., Kohberger's phone was utilizing cell service, utilizing cellular resources that provided coverage to his apartment. They support the idea that he left his apartment and went south. They supported the phone being off. They supported at 4:48 a.m. that the phone in south of Moscow near Blaine, that's when the phone came back on. The phone utilizes resources that make their way back to Pullman, coinciding with a white Elantra seen on some surveillance there. Yeah, there was no surveillance of that car outside of Moscow all the way back to that apartment until it got close to the apartment. It's in that rural area. There's hardly any cameras out that way. A similar data showing occurs at approximately 9 a.m. with a trip into Moscow and returning at 9:32. That was the next day. Because the PCA claims that the morning after the murders, his phone pinged right there by the house again and was only there 10, 12 minutes, and then it left. The same team determined Kohberger had been to Moscow at least 12 occasions prior to the event, and that he came into the area that morning following the murders. However, law enforcement without explanation indicated it did not believe the final trip ever occurred. At 2:43 p.m. on December 29, a criminal complaint and probable cause order were filed in this matter. At 10 p.m., Pennsylvania SWAT began preparations to arrest Kohberger. Despite days of constant FBI surveillance, Pennsylvania law enforcement did their own surveillance starting at 11:15 p.m. And despite the fact that the constant FBI surveillance showed Kohberger was unarmed and tended to go for runs around his parents' neighborhood, police decided that in the dead of night, within his parents' home, was the best way to make the arrest. Well, at 9:25 p.m. on December 29th, the Superior Court judge in Washington issued a warrant for Mr. Kohberger's apartment in Pullman. The warrant was based on the affidavit of Assistant Chief Dawn Daniels. Where'd you go? There he is. There she is. Heather. They just brought her up. She had a problem with the IGG stuff, this officer did. Requested the assistance of WSU Police Department in investigating the case. The affidavit relied on same information outlined above. On December 30th, at 2022, at 1:14 a.m., Pennsylvania, SWAT and federal agents raided Mr. Kohberger's home. Law enforcement arrested Mr. Kohberger. On December 30th, Idaho State Police, Moscow, and other law enforcement searched Kohberger's apartment at the Northeast Valley Road. It's a danger. I wonder if they really were following him all the way across country back into Pennsylvania. We were pretty sure that the FBI was following him. They had their eye on him before he left the state of Washington. The argument here: this court should apply Idaho's exclusionary rule of law to this search. The first question the court must determine is whether there is a conflict of laws in this matter, whether Idaho law or Washington law controls the validity of the thief. Unlike the issue of arrest warrants, cases involving multi-state investigations have produced far less case law. In fact, the defense could not find a precise case on point for the state of Idaho. The issue, however, has received some attention in academia. Professor Kerr argued in his article for Harvard Law Review that the jurisdiction where the crime occurred should control how the investigation is done, but that states and or federal government should provide some form of authorization to each other to participate. She's saying they didn't? Because they were. I'm a little confused by that. Let me check chat. Fortunately for this court, Idaho and Washington do not differ in their approaches to enforcement of the Fourth Amendment analog provisions. Both do not accept the good faith exception. Thus, the court can likely afford to leave us an open question which forms exclusionary rules apply. However, it is clear from the grounding of the exclusionary rule, the evidence obtained in violation of the Constitution must be excluded. Thus, Kohberger argues that the Idaho Constitution exclusionary rule must apply, as its basis lies not only in deterring police misconduct, but because exclusion is constitutionally mandated in the judicial integrity. However, it remains to be determined whether the actions of the FBI and WSU police should be viewed through the lens of Article 1. Is she saying that, Lord, I got to reread this in a little while because she's confusing. Is she got a problem with the FBI working in conjunction with states? Because that's what they do, right? Like they weren't out there on their own, I don't think. They were assisting because it was across state lines. Otherwise, like, they weren't at the search of his apartment. FBI wasn't. It was Pullman police led that search, not the Idaho police. This approach should also mesh well with older cases. Lord, if she's going to go start reciting 1800 law again, we're not going to listen. However, this concept has its detractors. McGlynn argues that when the CITES officer is performing the search, they should only be held to upholding their own laws. While the position has merit as it does not require a CITES officer to get a rundown of the differences between their law and the trial state's laws, it remains that Idaho Constitution is not merely concerned with deterrence to officers who misbehave. Heather, you're saying Tolleson was at the Kohberger's apartment? Because he's the one that's got the Brady, or, well, Sleuthy's got a pretty good video explaining all that on him. She hasn't made a video in so long, but that was one of her good ones. I hope he wasn't there. But this doesn't sound like she's singling out any particular officer. She's saying that they had obtained this search warrant based on that IG. And Pullman had a problem with wanting to make sure that y'all weren't just using this IGG to obtain this warrant. Remember, there was some talk about that. And they assured her they weren't. The affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. The Fourth Amendment states ambiguously that no warrants shall issue but upon probable cause, support by oath of affirmation, and particularly describing the place to be searched and the persons or things to be seized. Well, they did. They remember, because they described out, even they had to go back and get consent to search that little outbuilding attached to his apartment because it had the lock on it. And you have to be that's why these warrants are so specific, searching, the outbuildings, the inside of the home, looking for particular items. You can't just go through and take everything. You got to be very specific as to what you're looking for in these warrants. And we went over those warrants. We'll have to go over them again someday in this case. I do have somebody on Twitter who we're going to try to work on a back show and kind of like go from the beginning to where we are now. Based on back stuff, including roommates and all that. Yeah, they got to list all of it. And remember, we went over that search warrant danger a whole bunch of times, and it was all listed. So that's all that she's doing on this as well. I'm wondering now if all of these are going to be based on the IGG. Let's see real quick. Let's see. That was the apartment. This is the Apple stuff. Let me get this screen up here. A lot of folks were saying Brian Kohberger didn't have an Amazon account and all this stuff. Apparently he did. And what's in there that you don't want us to see? Is there anything? I don't know. Could be nothing. Could be just random shit he's buying like the rest of us. Don't get me singing, Joe. I know that whole song. Apple account, federal grand jury subpoena and search warrant dated. So this is, okay. This is the stuff that the grand jury was shown. And if she can get the stuff the grand jury was shown thrown out, she gets the case thrown out because he was indicted by a grand jury. We didn't do the preliminary hearing. We did it the opposite. It was scheduled. We were all ready for that damn preliminary hearing, and then boom, nope, we got a grand jury indictment, which is weird when you think he was already arrested and already in jail. That usually comes the indictment, then the arrest. I guess they're backwards over there than Florida, but that's what she's doing here. If she can get all these things, then if you throw out the grand jury, can they turn around and still do a prelim? And I wonder. Yeah, Danger. We looked up all kind of stuff. Our Google searches and our private talks and all the things we looked at pertaining to this case, we would look incriminating right now, wouldn't we? So bad. Like, y'all don't let nobody see my Google searches. So this is basically going to be the same thing. Let's see. Kohberger has a privacy interest in his Apple account. Yep. I wonder what all was in those warrants, though, that came back that we aren't seeing yet. I'd like to know. Was there anything, shady? Or was there just, like, nothing, like weirdo stuff like the rest of us would do? I don't have an Apple account, though. Mr. Kohberger has a privacy interest in his Apple account information. I say you got more of a privacy situation with your genetic genealogy. And that's why they're saying, a lot of times now when you go into these databases and you turn in your own DNA for like, family histories and comparisons and all that stuff. You need to start unchecking and checking certain things because they can absolutely come in and use you. Now, GEDmatch is a database for all the other companies they deposit the information into, and that's where they're like CC Moore. That's what she uses because it's harder to go into these others like 23andMe. It's harder to go into their systems and start looking into people's genetic genealogy stuff. So if it's not going to be, and if there's no, say like the suspect never uploaded a profile, I'm not going to be in none of those databases. I've never uploaded DNA to any of them places, and I have no intentions to do. Let me look at what guy sucks. Let me go back up here and read her comment. Joe, you still with us? Or are you on mute? Oh my gosh. Am I still with you guys? Something happened to my screen here. Hold on. There we go. Now I can see again. I feel you there, woman, because I don't back in too much, but it depends. But yeah, don't. Well, we'd all be in trouble, wouldn't we? All right, thank you, Butterfly. Joe must be taking a little break. Right? R&M, justice for backer. All right, let me slide this back over. Girl, I thought for a minute earlier your Twitter got suspended. I was like, what? I had to go look. I was like, I can still see her, so I'm good. On December 21st, the FBI issued a preservation request letter to Apple. On December 30th, this is all 2022, Pennsylvania law enforcement, along with officers from Idaho, the FBI, raided Kohberger's parents' home at Lambston Drive in Pennsylvania and arrested him. An iPad was located at the parents' home, but it was not seized because it was found in a common area. Huh, interesting. I wonder if we're going to find out what they took pictures of, danger, but left behind. There was something in the search warrant return from Pennsylvania, and they list all the things they took from the home. I'm sorry, Joe just messaged me on the side there. And so they took a photograph of something and submitted it to evidence, but left whatever the item was at the home, which is weird. Like, what could you not take, right? I guess if it's in a common area, you can't take it. So based on incomplete records available to the defense, the FBI served a grand jury subpoena on Apple on January 12th. So we were wondering why some of these warrants were coming in what would appear to be much later than normal. And Apple produced responsive data on January 27th for Apple accounts, and then it lists the accounts. The data was shared with Corporal Brett Payne of the Moscow Police Department. Subsequently, Apple sent an email to FBI's tactical specialist Maria Tyndall acknowledging receipt of a preservation request to preserve the iPad and its contents. Over the next few days, Detective Mowry of the Moscow PD was included in an email chain discussing Apple's response to the preservation request. Oh, Anne finally got all them emails she was after. Damn, girl. The communications referenced setting up a chat with Apple's point of contact to discuss issues that needed clarified or resolved. So were they really trying to look at that iPad without a warrant? The communication also include Apple telling law enforcement which accounts do or do not exist for Mr. Kohberger. I have no preconceived notions about this man's innocence or guilt. I will not take a stand either damn way, but come on, we got to start doing this shit right if we want to put the right people in the right jails. We can't be not testing DNA and losing interviews and getting warrants without damn, oh, Jesus, getting information without warrants. We no.
So I'll take
Yes.
any. I
I'm
have been
here.
I have been with you this entire time, and
Okay.
I thought it was my headset. So I literally switched through all 5 of my USB ports that I have. I'm like, is it this port? Is it this port? It was StreamYard. I was muted in StreamYard the whole time.
Oh,
Oh my gosh.
I'm in StreamYard, so I don't know.
I don't know how I got muted in StreamYard. I'm 99% sure that I didn't hit that mute button in StreamYard, but somehow I got muted anyway.
Yeah, it could have. Yeah. So Danger, remember we know that they had the shit, what was it? The Strava account. We believe that was Kohberger's Strava account. But I don't know if we don't see, we got a bunch of warrants for Apple and Google and all those things. There's no telling, and if one was wearing a health data watch, they would have to get that information off there. But were they obtaining warrants for everything, or are they setting up chats to discuss it? Like setting up a chat. That the communication also include Apple telling law enforcement which accounts do or don't exist for Kohberger. Now, was that done without a warrant? That's just a conversation between them. That's the problem. Like, if Kohberger is your guy and you got issues now because you didn't do it correctly, that's a problem. Just like it's a problem to put an innocent man in prison. If you want to convict the right ones, do it right. Hey, Firefly, our resident nurse, come and drop some knowledge on us. I was wondering the same thing when I saw that, Firefly. I wasn't sure if that would be a HIPAA thing or not with that. I guess you can still get the warrants and get the information off of there without having to go through HIPAA for that, huh? I don't know either, but let's see. So the communications referencing setting up the chat, the communication with which accounts do or don't exist for Kohberger. Perhaps recognizing that subpoenaing Mr. Kohberger's records was a violation of the United States and the constitutional law. August 1, 2023, Corporal Payne of Moscow Police requested a warrant for the same information subpoenaed from Apple Inc. by the FBI. See, the FBI was doing their own warrants as well. What, they're not working together here? Admitting in his affidavit that the FBI had already subpoenaed the requested information. Corporal Payne served the subpoena later that day via email. On August 7th, Apple sent an email to Corporal Payne responding to the warrant and providing access to the responsive data. So they did obtain the warrant. On August 9th, Corporal Payne and Detective Mowry downloaded the data provided by Apple in response to the search warrant. That was Exhibit E. We're always trying to figure out what these damn exhibits mean over here in Idaho under seal. Mowry downloaded the data provided by Apple in response to the search warrant. The data was inventoried and returned in return of search warrant prepared. I gotta make this a little bigger. I'm sitting too far back.
That's what she said.
Yeah, I should.
That's what she said.
That's funny. Okay. Now you're gonna make me start laughing and I'm not gonna pay attention to what I'm doing. I had to make this screen a little bigger because I had to blow it up for my old lady eyes. Okay. The data was inventoried and return search warrant was prepared. On August 1st, affidavit search warrant was signed by Brett Payne. However, most of the information in the warrant was cut and pasted from an affidavit originally bearing the signature of Moscow Police Department Blaker. They both have a PCA kind of. I got them in the Discord. We got the PCA, but we also have his. There was like 2 written, but they're kind of the same. The basic facts Payne used to support the search beyond those included in the arrest warrant were: The basic facts Payne used to support the search beyond those included the arrest affidavit were his knowledge of Apple and what data it maintains with the Apple ID, the method that iCloud users create, store, access, share, and synchronize data, internet-connected device, including backup of devices' data. On January 7th, Apple had responded to the federal grand jury subpoena that a full iCloud account under the name Brian Kohberger was in. Why? Hang on, I cannot see that. Does it say Wi-Fi Army owns? Can you see that, Joe, any better than I can? Wi-Fi Army owns at yahoo.com was inactive. That's a weird account. Using the information produced in the federal grand jury subpoena, Corporal Payne determined that the AMS subscriber account was linked to Kohberger. AMS subscriber _ account. Timing of account access as searched by Payne was around December 20th, when Payne knew Kohberger was in Pennsylvania, still assessing the Apple account with a known iCloud before the homicides. Account with a known iCloud before the homicides and then days before his arrest. Do what?
This is wow. This is like I'm going to have to go through this like line item by line item and try and figure out. So here's one of the things that Bob Motta criticized about the defense team in the Richard Allen case is they did not attack the timeline enough. And I think that's what she is doing right here.
Oh gosh, she's been tearing up this timeline from day one.
So
she's not playing.
Yeah, she's deep into it. So I'm going to have to unravel it like
almost
a lot of bullet point by bullet point.
You have to with Idaho. You almost have to. You have to sit down. Even the PCA, people are like, it doesn't make sense. Make it make sense. It's not. It's like all over the place. It's really not. When you sit down, you break it down, and you look at just all the car sightings. And I'm not saying it's accurate. I'm just telling you what it says. If you look at the car sightings, and you write those down in a column, the times and the location, then you read through it and you pick out just the cell phone stuff. It matches. Every time the phone was pinging, car was seen right there near where the phone was pinging throughout the PCA until it goes offline for those 2 hours. Then you don't know where it's at. But there's been questions about when was warrants obtained and all of that in this case because of the IGG that was used. If IGG hadn't been used, it wouldn't even be a question. Then that means they wouldn't have found him until the officer stumbled upon a white Elantra in the parking lot of the campus at WSU. Decided, oh, I'm going to run this car. It's a white Elantra. Oh, look, it comes back to a Brian Kohberger, so, so many feet tall, bushy eyebrows. Is that, I mean, how many white Elantras in town with guys that have bushy eyebrows? I don't know. I don't live there. You know what I mean? So if there hadn't been IGG used at all, she wouldn't be able to take that avenue to use these in her. But Ann Taylor is all about the timing of everything. She said in hearings months ago, when they're like, we've given you everything. We've given you everything. No, you've given me everything the FBI gave you. I don't want just your email, your official emails. I don't want just your written up statements. I want your notes, Dan Doolin, that you use to compile your statement. I want it all, the communications, the emails back and forth to one another, the text communications with each individual investigator. And that's how she's putting that timeline together, by looking at all that stuff. And she's been saying it from the beginning. I want it all. I want your notes. I need everything. And she really drove home trying to pinpoint when that IGG information came down versus the day they found that car in the parking lot. Because you can't use that IGG alone to get to the client or to the suspect. You're not supposed to. Well, Okay, Kohberger's a different breed, y'all. If you want to even go down the road that he knows how to get around a lot of the things that you would need to get around. So that phone thing and being turned off and the activity. Here's one theory. If Brian Kohberger did this, and they're saying he was over here driving around stargazing, could he? Now the phone is seen pinging going toward Moscow, so it kind of don't make any sense why it just goes offline if it's headed toward Moscow. Anne says it was never headed toward Moscow, it was headed the other direction. But when that phone goes off, if he drops it into a Faraday bag, does it preserve where that phone was last time until he cuts it back on? Could he drive around for 2 solid hours doing whatever he wanted, going wherever he wanted, and then go back toward the apartment, pull it out of the bag, turn it back on, and it looks like you were right there in that area the whole entire time? You see what I'm saying? I don't know. I mean, the guy could have just been driving around sightseeing. We don't know. At least I don't know. Didn't go offline, because if it did or didn't, it's going to be, yeah, the cast can see everybody's. This is why I get a little with these cases. Everybody's, with Libby's phone. Where's the FBI? The FBI has been telling us what was been going on with Kohberger's phone. Now they never said it was off for 2 hours, but the investigator did. I got to wait until the FBI guy gets into court to figure out what happened to that phone for those 2 hours. We know Cy Ray is going to testify on behalf of the defense, but Cy Ray used to work with these FBI guys, the same ones that are going to be testifying against his knowledge when it comes down to trial. And we have to remember, I'm not throwing shade, but there's been times Cy Ray's work was not even been allowed in court. So you have to take that with a grain of salt. Yeah. Danger, I would agree with that. That was her point when she said he was out riding around stargazing. She's saying he never went toward Moscow, but that's not what the PCA says, and we all see that. Or if you've read it, we haven't read it in a very long time, and I do want to go back over that, but I won't do it tonight because there's so many of these. So, okay, timing of account access search by Payne was around December 20th. Payne knew Kohberger was in Pennsylvania. Payne requested a very broad time frame of October 7th through December 30th. Now, are they assuming that iPad found in the parents' living room was like the community iPad for the family? Y'all can all just pick it up, and I don't want my account on somebody else's device we all got access to. I mean, we can put passwords in and stuff, but no, I'm not doing that. I just don't think the family's going to share the iPad. Unless it was mom and dad's and he logged onto his account from their iPad just for shits and giggles or whatever. I wouldn't. I'd be like, I got my own. Mr. Kohberger has a privacy interest in his Apple account. Danger, didn't we also hear everybody saying that he didn't have any kind of Apple devices? He only has a Android, so there's none of those warrant. Those are all the students that were killed. Those warrants are all for their stuff. That's what everybody kept saying. And it obviously isn't. It wasn't all just for them. There was a lot in there for him as well. So he did have certain accounts people think that he didn't have. And I don't know where they determined he didn't have any Apple accounts. I'm like, how did y'all know him? Did y'all know him? Mr. Kohberger has a privacy interest in his Apple account information. Go ahead.
I was going to say, why? So Danger Zone's question here, did any of the victims have fitness watches? Surely fitness watch data is not protected by HIPAA. That's not in any way, shape, or form connected to any licensed medical practitioner. So
yeah, and that's what Firefly agreed. She said no, and she's a nurse. She said she works for she has a lot of knowledge in this, so I've talked to her so many times about different things, but she said the same thing you're saying, that it would not apply. HIPAA wouldn't need to be used.
Yeah, well, I have no medical knowledge, but I did sleep in a Holiday Inn Express last night. No, not really.
Right? Well, it's not keeping detailed. I mean, like.
Well, it's not associated with a licensed practitioner of any kind. So When you
Right.
go to your doctor, when you go to your psychiatrist, when you go to your psychologist, those are medical professionals. So that information definitely is protected by HIPAA, and
Right.
that's what the HIPAA is for, but not smartphone data, watch data.
Well, it's just recording your steps, your movements, your blood pressure, and things like that, and you still got to get a warrant to obtain those things. You
Right.
can't just go like, oh, I'm gonna take this watch off and go through it. They still got to get a warrant for it.
Right.
But there was a lot of talk in this case very early on that no, Kohberger, the students, because it was their fault. Like, I don't know who did this, but I'm not about to blame these victims because nobody's brought me anything I can sink my teeth into that shows me they caused it. I've got a whole alternate theory laid out in my DM. I mean, I do know the theories. I do. There's just so many different ones, and none of them. Anne doesn't talk about any of those in her filings, so I'm not giving them any of my breath. This ain't like a Frank's motion we saw over in Delphi. That we wouldn't have been talking about Odinism if it didn't come right out of a court document. All records or other information regarding the identification of the account to include identifying information of the account owner. So again, she is saying the same thing about this cloud or this iCount. Why would you need to have different warrants from different agencies? You couldn't share the information. Why was the FBI's investigation separate from theirs to the point? Are they not sharing information? They got to be, because that's what made everybody mad in Delphi. And they're like, no, FBI, we don't like what you're saying. Get out of here. So we know they talk and share information. It's crazy. Let me see if she's got anything else to say besides all the standard. Okay. Let me go back right here, though. Such information included in device backups, private emails, documents, photos, and videos that predated the applicable time frame that Kohberger was in the Moscow-Pullman area. Mr. Kohberger has a privacy right protected by both the Fourth and so she wants to make sure they're looking at only the times they had applied for too, that they didn't go outside that scope. You know what I mean? They had to stay within those parameters that they requested to look at. To the extent that this court might see this as a third-party doctrine issue, the arguments made in Kohberger's memorandum in support of suppressing Amazon records fully argue that doctrine are incorporated here. The affidavit submitted in support of the application for the issued warrant recklessly or intentionally omitted material. But she hasn't really said what that was except for the IGG. Okay, all information in the affidavit was gathered because of law enforcement's unconstitutional use of IGG. But what she needs to do now is show me documentation of when that IGG came down. You know what I mean? When they decided, like, okay, here's the day. Look, guys, the tree is complete, and it's showing it goes back to this guy. What date was that? Because that's what she's going to be looking at. I'm assuming she's got something to do with that, or she wouldn't file these and make herself look silly. Sounds like to me Anne's convinced they got IGG before they did the car. Motion to suppress the arrest warrant itself. Joe, do you want to start reading this for a minute while I run to the restroom and fill my coffee back up?
Sure, I gotcha.
Okay.
I'll try and read really slow.
Okay, there you go. Issues. I'll leave it right there. I'm just going to go grab some coffee and I'll be right back.
All right. So, motion number 2. It looks like 2 of 8. This court should apply Idaho's exclusionary rule and law to the search. Item Roman numeral 2, the affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. Mr. Kohberger has filed a motion for a Frank's hearing and without repeating incorporates that challenge to this search warrant. Roman numeral 3, the affidavit submitted in support of the application for the issued search warrant included information that must be excised. I would have liked to have seen some of this in Delphi, because that probable cause affidavit and search warrant affidavit, probably some of these arguments may have applied. All information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy, IgG, and thus nothing in the warrant should remain fruit of the poison tree. Information about the client's location taken from his phone must also be excised due to being gathered from an invalid warrant, fruit of the poison tree. Facts due to the haphazard way in which law enforcement oh my goodness. The connections between the two are just unreal.
I know.
And here's the thing. When I first saw, here's the thing, Bob Motta says that all the time. So I probably shouldn't, but here's the thing. When Richard Allen was first arrested 2 years ago, exactly 2 years ago, almost, I was like super glad. I'm like, okay, they caught the guy that killed Abby and Libby. We're going to see justice. And then we saw all of that unravel through all the different things. So my opinion changed from he's definitely the bad guy to I'm really not sure if he's the bad guy or if he was involved in any way because of how shitty the investigation was and his incarceration. Like I honestly don't know to this day if he's guilty or not, or participated or not. But Brian Kohberger, I still have a feeling that Brian Kohberger may be the bad guy in the Idaho 4. Like,
oh yeah,
I'm at like 80-20. I think he's
yeah.
80% guilty, 20 not. So that's where this comes in.
Yeah, I think I'll always be at 50-50, I guess. I mean, the DNA on the sheath, I know, I get it. Everybody screams that transfer, but what you got to realize is when you get to court, you can't just say, oh, that's just transfer DNA. You have to have an explanation for the transfer of the DNA. Like, I sold the K-bar knife I once owned that I bought from Amazon, and I sold it at this knife. And you go track down the guy I sold it to, because that's probably who did that. Just my spec was left on there. Those, you can't just walk into court and make that your argument. You know, over in the Herman case, one of his victims had a hair that belonged to Rex Herman's wife. Did that mean she was in on the murders? They called that transfer DNA from his vehicle that the wife was always in, transferred to the victim once she was in the vehicle. Now, could that be very plausible? Yes, indeed. We also know in that case hasn't went to court yet. They haven't implicated her yet. I'll just say it like that. But there's another case where there was a transfer DNA issue, but they were able to prove how that happened. So here you just can't say, well, I went to the store, changed my mind on the damn Cheerios, put them back. That lady come in, bought them, took it home, and blah, 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 transferred my DNA off my cereal box onto her knife sheath. That don't make any sense. Did y'all not wash your hands in between all that? Like, you know, there's a lot of questions there. But with Kohberger, like, if they didn't have that DNA, I don't know what else they got. You see that if that Linda Lane footage is no better than what we've seen that was leaked, and if 1122 or 1112 can't see that car better than, we don't know what that camera sees because that hasn't been leaked.
Right, but what is the jury going to see though? Because if the state of Idaho does what the state of Indiana does and did, and they take that automobile coverage to be like the Hoosier Harvest Store coverage, I would bet you dollars to donuts that the people that look at the still photos of the Hoosier Harvest Store video would not be able to place Richard Allen's car in that video any more than they would be able to place Brian Kohberger's car in that video in Idaho. So we have equal evidence, and It's all dependent.
The
It's all
difference
dependent.
is, well, the difference between that video is it wasn't collected 5 years later. They didn't just go get screenshots. They went out and collected the videos pretty early on, you know what I mean? There's a neighbor sitting right next to the King Road house that faces the intersection of Queen and King Road. They obtained their video, and that allegedly shows the car coming right off of the high. It's not the highway, it is Taylor Avenue, coming into the neighborhood. It was when you come off of Taylor and turn onto King, you take a left onto Queen, and the house technically sat on Queen Road, but it was called King Road by the locals. That camera spots a car coming into the neighborhood at least 3 times. And then it also, when we see the Linda Lane footage from behind there, where the car comes in the neighborhood, drives up Queen, and goes around the apartments, all that coincides. But there are people out there who've done overlays that really are compelling to it being a white Elantra, but that's sticking an overlay onto something. It
Right.
looks a lot like it, but you can't see who's in that car. You can't tell what color that car is. Do you know what I mean? And on the Linda
Exactly.
Lane
And
footage,
that's exactly the point that they made in the
Yeah.
Richard Allen hearing. They said, can you
Yeah.
see who the driver is? No. Can you see what the
Yes.
license plate is? No. Can you see the VIN number? No. The only thing that the law enforcement officers testified to was, the wheels were such that we knew there were spokes on the wheels because we could, quote unquote, see daylight through the wheels. And there were 2 law enforcement officers that testified exactly the same. We can see, quote unquote, daylight through the spokes in the wheels, which is interesting that they testified exactly the same. So they got their story straight, and whether it's an accurate story or not, we don't know because we don't have that video evidence. So yeah,
Yeah.
there are similarities, and the similarities that I was interested in was because I got to that first statement after the facts. Due to the haphazard way in which law enforcement, whatever is after that, doesn't matter to me because that's what happened in the Delphi case. Due to the
Yeah.
haphazard way that law enforcement did their investigation, there are questions. We all have questions, and we all don't know and won't know, maybe ever,
Right.
some
Well,
of the
they
answers to
need to
these.
conduct their investigations thoroughly and let the not be like, oh, stuck 5 years, we got to get somebody, or I know that there was implications that Brian Kohberger is doing undercover work, and now all of a sudden he's being framed by the people he was doing undercover work for. Well, I think he would have told Ann Taylor by now, hey, look, I'm their patsy, I'm their this and that. She's not afraid to go up against the FBI. Ann Taylor has been taking on the FBI since the day she took on this case. And, I mean, honestly, all they have in this case is the DNA on the sheath. They have the white Elantra, or they have a sedan near the home. They have cell phone pings showing him going toward the home and allegedly his car. There's multiple videos out there, though, that we have not seen, right? I don't know how good some of that footage is. Now, there have been Doc Thrifty's channel is gone now, and I can't pull the video back up, unfortunately. Firefly, I know you're with me on that. He did an excellent video, and he drove from Pullman, took the route that they claimed that Kohberger took, and he could point out every single camera, all the cameras. There were so many cameras, but this car was seen on a bunch of different cameras headed toward Pullman or toward Moscow. So what they show, we don't know. All we've seen is what was leaked of Linda Lane, and Linda Lane is grainy. So I don't know if they got footage of this guy better than what we know of. Do you know what I mean? I hope they do. They're going to need it because the physical piece of evidence you have to tie him to the scene is the sheath, and to support it, you got the cell phone we are aware of.
You know what? That's more than they had.
there's
That's more than they had to tie Richard Allen to the scene of the crime
way more.
along the banks of Deer Creek. They had no DNA. They had no physical evidence other than the unspent round, which was challenged in court. And,
Yep.
and apparently, so the only thing that is the huge difference in the two cases is 61 confessions versus 0 confessions. That's
Oh,
the
yeah.
huge difference.
And there was a lot of speculation out there that it was Brian Kohberger was the getaway driver. He was not the only one. Kopacka was involved in all these things, but according to Brian and Dylan and all that, but according to Kohberger, there wasn't anybody else involved. He wasn't even involved. He was just out driving around that night. He didn't say, I was with Kopacka. I picked him up and I took him over there and he ran in and grabbed my sheath and went in there and ran back out and into story. He could have done that, but he didn't, so I mean, Kopacka wasn't here to dispute that. He was gone. He taken out by the police. So I don't know. He says I was not there, period. I didn't even go that direction. So how'd your sheath get in there with your DNA? Now that's the thing. If the DNA was only on the snap piece, are we to logically assumed he wiped it before the commission of the crime? Well, yeah. Okay, if you're about to commit a crime and use your knife, you don't want to leave nothing on it. So I always thought that. I mean, why would you not? If you've handled it when say you received it from your Amazon order and you open it up, are you gloved up already just so you don't get nothing on there? Or do you handle it for a while, you become familiar with it, all the things, and then being a criminology student, do you know to clean that thing thoroughly? But did you accidentally leave a little bit on that snap? Just enough to get you. And if that's true, do you know how much he probably hated himself for not grabbing that sheath before he left? If it was him? Otherwise, you got to explain how that got in there. Notice she's not saying that's not my client's DNA. Not yet. She does allude in a past hearing that, that suppression motion to suppress that sheath is coming. Based on what yet? I don't know. Is it going to be like a chain of custody thing? There was talk about how it was found and all that kind of stuff. But she's not disputing that it's his DNA yet or how it got there yet. She's just saying your warrants are not any good because you got that investigative genealogy. Let's see. Basic facts Corporal used to support the arrest are discussed in detail in a separately filed motion. Separately filed motions. I want to know what that is. At 2:43 on December 29th at 2022, a criminal complaint and probable cause order was filed in this matter. At 10 p.m., Pennsylvania SWAT began preparations to arrest Kohberger. Despite days of constant surveillance, Pennsylvania law enforcement did their own surveillance starting at 11:15. Wouldn't they kind of work together and be like, hey, you're going to notice there's 2 different vehicles out here. Y'all come get in mine. Let's just carpool or whatever. I don't know. If you look at the surroundings of his parents' home, it's like, where'd they hide out to watch him? Like, I tried to figure that out one day. Like, I'm all over some maps when things come out, and I looked all over that neighborhood thinking, where in the hell were these cops sitting to watch this guy? The one time the cops sat across from me where I used to live to watch the other neighbor who was like a big-time pot dealer, they parked in the old man's yard that you don't even look at his grass sideways. Like, you did not mess with that old man's property. You didn't look at it. You didn't walk on the same side. You just didn't go anywhere near it. Then all of a sudden, there's a random car parked in his driveway facing one of my other neighbors. And I walk out my front door and I'm like, huh, who in the world is that? And 3 nights in a row, that dude sat there. And when we went to see the guy ease back, thinking we weren't going to be able to see him sitting in that car. We knew for a fact somebody on that street was being watched, and then they were, come to find out, but it wasn't me, thank God. I wasn't doing nothing wrong. But I knew that guy was a cop sitting over there in that car. So you got to be inconspicuous, or the people who live there or who are nosy are going to know you're out of place. And I just couldn't see anywhere they could have sat undetected, you know what I mean, without someone noticing a weird car outside all night. Now you got a couple of them, got all kinds of law enforcement out there watching. And despite the fact the days can, I got to blow this up so I can see. I think I need to go back to the eye doctor and get me some regular glasses and stop relying on these cheap ass readers I bought, because I broke my real glasses. SWAT began prep to arrest Kohberger. We already read this in one of the other motions, didn't we? December 30th at 1:14, Pennsylvania SWAT raided the home. And then she goes through all that again. The argument is the court should apply Idaho's same exclusionary rule to the search, because she's saying that they used the IGG material to obtain the warrants. Okay, so this one was for his arrest.
So the fruit of the poison tree argument is going to be huge in this.
Oh yeah,
That goes back to the IGG. Like if
yes.
the IGG is denied, that's going to eliminate a whole shit ton of evidence. Like the state's case is going to be wrecked.
Yeah, if they did that, if they used that IGG alone to get to him before. So what if you are actively doing an IGG tree? Because we know it's been used before in the past. So if they're doing one and they get the information back, they're like, okay, well, this is what it's showing us. They are not supposed to be able to use that alone. But they did use that alone in the Golden State Killer case. That's literally how, then they went and got his DNA and compared, and it was a match. When they got Rex Horman, he threw out the pizza crust. They went over there and got it, and it matched some of the DNA they had gotten back off their victims. The IGG wasn't, I don't know if it was actively being stuff. Sleuthy and I were talking months ago in a Twitter space about it. Will it change things going forward with the way they're allowed to collect information on us? Do you know what I mean? As far as investigating us, like these geofencing warrants, so they're now are not going to be allowed anymore because they were so broad and vast. Once you collect the data from within the zone, I got 50 to 100 people now. They're all being investigated, and they have no idea whether they did something wrong or not, whether I have probable cause to investigate them or not. Now they're being investigated. That is now illegal. So, too bad Delphi didn't go to trial sooner. Nick may not have been able to keep his damn geofencing stuff out of the court because it was used a bunch of times before. Now, this one is for the AT&T first warrant. Let's see. Suppress the AT&T first warrant.
KK, I would disagree with you just a little bit that she needs to spend more time working on the case and less time trying to file for nonsense. If you don't get your objections in as a defense attorney in the pretrial motions and then during the trial, then sometimes you close the door on appeals. So you're actually throwing a whole bunch of stuff against the wall to see what sticks. And 90% of it as a defense attorney is not going to stick. The court's going to rule against you, but you have it on the record. And so eventually down the road, you can appeal. If you don't get it on the record, you can't appeal.
You have to get it all on record. And that's what she's doing. But so curiously, I'm not spend more time working on the case. There's not much for her to work on other than how you got to my client. Did you legally obtain all these search warrants? Things of that nature. There's not much more. She's not going out there and trying to investigate who the real killers were, obviously. She's not even alluded to an alternate tunnel theory or anything like that. She's going to have to prove her client didn't do this. And how is she going to do that? Can she even do that, right? We have to wait and see how she fights that sheath, because that's going to be the biggest piece of evidence against him. Because the eyewitness, Dylan, doesn't see anything except some bushy eyebrows and hears some noises and hears some talk going on. Lord knows the girl could have called 911 a lot sooner. But yeah, she's She's doing what defense attorneys do right here, honestly. And actually, she hasn't really requested more time. She's requested a lot of information, though, that's been coming to her slowly. In her defense, it has been coming out to her slowly. But I think she does request a lot more than a lot of attorneys would, because it's a death penalty case. And that's what she does. Okay, the facts of the case. December 23rd, Corporal Payne of the Moscow Police Department requested a warrant to search the contents of Mr. Kohberger's AT&T account. So he does have an AT&T account, people. Regarding the phone's whereabouts between November 12th and November 14th, as well as all messages, phone calls during that period. The affidavit for the warrant was signed by Payne. The basic facts Payne used to support the search are discussed in a separate motion for the Franks hearing. I'm assuming in that Frank's motion, she's telling them all about how they got the IGG first, and that's what they were using to obtain on their client. Yes, ma'am. The affidavit for the warrant was signed by Payne. Payne used to support. Okay. So again, going through all of the customer subscriber information included any listed addresses, all the things that would be stored on your information there. Call data, detail records, all the cell site information to include all known cell towers with outgoing and incoming calls, which is your call detail record. Cell site locations for their service providers, and there's the sector information, including azimuth headings in the regional market associated with requested cell site information. And she's just listing all the things that can be found inside of your account. Again, Mr. Kohberger has a privacy interest in his AT&T account, and the information is protected. So again, she's saying the same thing with this warrant, that they're using IGG to obtain all of this. I'm just going to be so curious to how she's going to prove that. Like, I want to see those dates. Where's that at? And I need to see that kind of stuff. Like, I've been excited waiting on her to give me something. Like, give me something. Like, I just want the right guy to be got in every case, but they got to do it right. Motion to suppress cell phone USB file and warrant dated January 9th. Sorry, guys. There's a car outside my house, and like, I don't know what they're doing. Everybody's gone. I'm the only one home. Like,
stranger danger. Stranger danger. Call 911.
They better be the ones worried. Let me just go ahead and say that. I'm in Florida. I got to stand your ground. I've been right here in my house.
I believe it. I 100% believe it.
Dynamite comes in very small packages. I think that's my son's friend's, his friend getting dropped off here that's been staying here or some shit. I don't know. I know my son, his girlfriend took off to the beach for the night. Okay, let me get over here back to what I was doing. That distracted me. The affidavit submitted in support of the application for the search warrant recklessly and intentionally omitted material information. So what did that recklessly omit, or intentionally omit? That they found him because of the IGG. All information in the affidavit was gathered because of law enforcement's unconstitutional use of IGG. There she is. So this is all she's stating all of that on. Pennsylvania law enforcement, along with officers from Idaho and FBI, raided Mr. Kohberger's parents' home on December 30th, 2022. During the raid, law enforcement seized Mr. Kohberger's cell phone. After seizing the phone, FBI SSA Jeffrey Tanzola made a copy of the contents on the cell phone on a Seagate 2 terabyte external USB drive with the serial number, and there's a serial number listed. Oh, that's took me back to some deep dives on early warrants me and my friends were doing. Like, there's some of that. Look, Firefly, we're learning what some of that stuff was. We were wondering what was. On January 9th, 2023, Detective Lawrence Mowry of the Moscow Police Department requested a warrant to search the contents of the USB drive at the same time stored at the forensic lab of the Moscow PD. The affidavit for the warrant was signed by Detective Mowry. However, most of the information in the warrant was cut and pasted from an affidavit originally bearing the signature of Blaker. But according to Mowry, now the sworn statement of Payne. See, they got these dudes, man. Y'all figure out who did what. They'll be sharing your stuff and like, oh, let me just copy and paste and I'll sign yours, you sign mine kind of thing. No. The basic facts Mowry used to support the search warrant were those used to arrest Mr. Kohberger and are the subject of the Frank's motion. Additional facts related to the cell phone data are as follows. The phone was seized when Kohberger's house in Pennsylvania was searched. The data on the phone had already been extracted by the FBI. Data on the phone had already been extracted by the FBI. What, when it was seized? They'd already done that? Data on the phone had already been extracted by the FBI. The search warrant for Kohberger's family home in Pennsylvania is also the subject of a motion to suppress. If the search of the house is suppressed, that will be an additional ground to suppress the phone. And then we know what the argument is, and then we're not going to read all those case laws that she's going to cite. So again, another unconstitutional use of the IGG. And that was for his personal cell phone. And then there's some more here with cell phone data. Let's see what this one says. Get this up here. Granted, which I don't know how this judge will rule, if he would be like, nope. Now, according to Andrea and to another person that I talked to on Twitter, in order to get this Frank's motion, or to get the hearing, they have to prove that the defense, let's see. They have to show that there was a misleading statement used to get these warrants, or any kind of misleading or omission. So if she can prove they omitted things to get these warrants, then she can get her Frank's hearing. And then she can get a hearing to hear all of this, to decide. I hope they don't deny it, because we saw what happens when Frank's motions get denied over there in Delphi. Shit just goes south real quick, like give them the chance at least. Let's hear her out. That's where I'm at with it. You know what I mean? Right, that's what it was, the way it was reading to me, DB. If that's the case, then that's not cool. Motion to suppress cell phone USB. This is the one we just read. Okay, so then they went down to the Google. Now they want the Google search done the same way. Was this all his Google searches? Everybody said he didn't have that either. Like, this guy lived in a fucking bubble and didn't have nothing. He didn't have no phones, no accounts. He just didn't do nothing. But apparently he did have some accounts. Just like that Amazon account was actually his and not somebody else's. Motion to suppress memorandum in support. Google warrants dated January 3rd of 2023, January 24th of 2023, and February 24th, 2023. That's 3 different searches, all in 2023, and he was arrested in the end of 2022. Let me get this a little bigger again. Okay. What you laughing at? Somebody's comment?
No, that's what she said. Let's get this a little bigger again.
There you go again. You need some pills over there, Joe.
No, I don't, but thank you for asking.
She, no, that don't math, does it? R&M, you cracked me up, girl. Okay. So now comes, Brian Kohberger, through his attorneys of record, submit the following memorandum, blah, blah, blah. I want to get down to the nuts and bolts here. We know all this. Facts. We know that part. Pennsylvania law enforcement, along with officers from Idaho and the FBI, arrested Kohberger December 30th. I think the dog's trying to get in here. Subsequent to Mr. Kohberger's arrest, many warrants were executed. On January 3rd, Moscow PD Mowry began work on Google warrants. He obtained Google Warrant 1 on January 3rd. A search warrant for all data available in the Google account in connection with the email brianchristopher1994 at gmail.com. Is that the year he was born or something? Like 94? Plus 2 phone numbers and an IMEI number. 2 phone numbers. So not all those search warrants were for the students' phones again.
Wow.
Everybody kept saying they're all the students' phones. They're all the students' phones. Like, how they have 50 phones apiece? I got 3, but come on, I only use 1. Well, actively. Plus 2 phone numbers and then IME number. Okay. On January 25th, Mowry obtained a Google Warrant 2, a search warrant for all data available in a Google account in connection with, here we go again with that weird email, YEWSRI. That's not the same one as earlier. Hold on, let me blow that up. I can't see it.
No, that's definitely not the same email address as earlier.
It wasn't. It's different. YEWSRINEIGHRN at gmail.com. So the guy who had nothing all of a sudden has a couple of email accounts. Okay. Well, I got 3, but 2 are business and 1 is my salty sleuth. It's not unusual to have more than 1. Okay. I lost my place. Where'd it go? Right there. No specific nexus is mentioned in the second warrant for the new email account, other than it was identified. No nexus to Kohberger. Is that what she's saying? On February 24th of 2023, Mowry obtained Google Warrant number 3, seeking all data available in relation to Kohberger. No reference is made in that affidavit to a nexus between Kohberger and BK5781 at Gmail. Google Warrant 3 adds the email account BK5781 at DeSales. That was his email at DeSales University, because he went there first. The warrants have no limiting language in the search and no justification for duplication. Google Warrant 3 return signed by Payne on March 14th references a warrant return only for the wrong email, Brian Christopher at Gmail, instead of Brian Christopher 1994. Oh man, you got a warrant back on the wrong email? Damn. The receipt and inventory, also signed by Payne, references Brian Christopher at gmail.com and the YEW, all that other one. But the return or the receipt and inventory report nothing about BK5781 at DeSales. This is particularly noteworthy because email communication between Mowry and Google on January 4, 2022 referenced Google not producing data on non-personal accounts. That was a school account. Mowry indicates they, meaning DeSales, are going to be able to help us with their end of the process, so that should be taken care of. Yet BK5781 at DeSales found its way into the Google Warrant 3 without any nexus or explanation. Well, the nexus would be they're all tied to him somehow, if they can prove that. The information in the warrants was cut and pasted from an app. Oh, okay, we already read all that. We know. Details about Google as a company and what it stores is based on Mallory's personal knowledge. A request for any accounts associated with Kohberger for any time periods. Kohberger was observed entering a CVS in Pennsylvania on December 16th of 2022, after he got back over there with his dad, and his email account, Brian Christopher 1994, and the phone number was somehow obtained by law enforcement. Kohberger was observed entering a CVS on December 16th. When did he arrive back in Pennsylvania, Danger? I can't remember. Well, it was obtained by law enforcement because they were following him if they followed him into the CVS, if they knew he went to CVS, and they surely went out scouring for videos in case he went all these places when he got back home. He was being followed.
Did he go ahead and take pictures of his car backed into a parking space at the CVS?
Right, dude, God, here we go. Damn. The CVS. Jesus. Was he a backer inner? Yeah, he could have been because he backed up at Linda Lane. Then he come back around that third time and went around, or let me rephrase that. A sedan, because I don't know who's in it, did all that. And it backed up once. I'm going to call him a backer-upper now. He likes the CVS too. I do not like CVS. Too crowded, too much bullshit. I like my small town, tiny little pharmacy that mom and pop owns. I refuse to deal with CVS. Put me on hold for 45 minutes. I'll teach you.
Ask for my phone number at the checkout. I'll teach you.
The Google.
I will hold up this checkout line for half an hour while we figure out how to put my phone number and email address into your system.
Look, I can't even stand going into stores anymore that don't have a self-checkout. Like, people are like, oh, what about their cashier jobs? Like, I don't want to talk about the weather or how she hates her job. Just let me go ring up my own stuff because I want to get in and get out. I don't like being in these places. They just get on my nerves. And now my Dollar General done took away the self-checkout, I guess because of thieves. Like, now I got to stand in this long line while y'all chat it up. I just want to get out of here. So, yeah, y'all all know now I don't like the CVS. Woman drives a hatchback. Stop it. She'll be changed her name in 5 seconds to just that. I laugh at her all the time. I love it. Google Warrant 2, January 24th. The new email is referenced as having been found in Google Warrant 1 MDW email. Also added a high probability a VPN was identified in Google return on 1/3/23. For Google Warrant 3, a new email, the DeSales, is incorporated into the third warrant without any supporting explanation. And she says, see Exhibit C, which we can't because y'all got it under seal. The affidavit, and then there goes into her argument about them omitting and are intentionally and recklessly omitting material. So, we all know what that's all going to say. She's like, nope, this just don't matter. You got it nefariously. Information gathered about Mr. Kohberger via previous invalid warrants must be excised. So, he had several emails they were looking at, though. That's crazy. The search warrant fails to command law enforcement to search Google accounts. The warrants in this matter fail to actually provide a command to search the Google account. What do you mean? I would like to see that. Don't you word it like that, right? Like, I want to look at this Google account. Send me back this information. The warrant in this matter failed to actually provide a command to search. They state, there are grounds for issuing a search warrant. There are grounds to believe the property referred to and sought upon said Premises consist of information related to investigation of crimes on the Google account of. That's kind of like how you need to word it, right? The command, we don't know for sure this guy did something, but we need to try to figure it out. So that's why we want to look at this stuff. The command is made to search the premises of the property and seize it. The premises is Google LLC at 1600 Amphitheater Parkway, Mountain View, California. There is no incorporating language for the search warrant affidavit. She's attacking how that search warrant's worded for the Google accounts. Because Google is really changing the way they store things, and they're making it more difficult for law enforcement to get stuff from them when it used to not be so difficult, for them to do that. And it's just like some cell phone companies make it very easy and some make it very hard. It depends on the company. And we know Google already changed some of the ways they were doing the data because of the geofencing warrants that were coming down. There's a whole thing about that, how they were going to start changing the way they kept certain information because they were getting hit with so many geofencing warrants. In striking a balance between law enforcement interests and rights of individuals to be free of unreasonable search and seizures, the process of segregating electronic data that is seizable from that which is not must not become a vehicle for the government to gain access to data, which is it has not probable cause to collect. Well, I agree with that. There must be some threshold showing before the government may seize the haystack to look for the needle. Ooh. The 3 Google warrants lack appropriate particularization for 3 separate email accounts, 2 phone numbers, and 1 IMEI number. So he had 2 phone. Did he have 2 phones or what? There's 2 phone numbers there. So we all speculated that he did because it looks like the warrant showed he had 2, but everybody's like, no, that's not his warrant. Well, it is, people. Read it again. You talking to me? I will read that again. What was I reading? In striking a balance, right there. In striking a balance between law enforcement interests and rights of individuals to be free of unreasonable search and seizures. The process of segregating electronic data is data that is sizable from that which is not must not become a vehicle for the government to gain access to data which it has not probable cause to collect. There must be some threshold showing, therefore, the government may seize the haystack to look for the needle. Like me, you're like, Google, Google, Google. What are we looking at? Right? I couldn't imagine working for Google, period. God, Lord. So they're going to tell this list all the things that your Google account will store on you. Your account, subscriber information, your emails, your messages, your Google Pay, your calendars, your contacts, your photos, your videos, your albums. Lord, if they looked at my phone and saw all the photos and people I don't even know, I mean, all the cases we look at, all the Delphi information alone on my phone is so incriminating. Well, it wouldn't be incriminating to me, but they'd be like, why you got all this? Like, none of your business. Back off. Get out of my haystack. Android records and Android devices and all the good stuff. So the Androids were all his. YouTube. Wait, because here, YouTube registration, email, channel ID, display name, IP logs, and account registration. We know that there is warrants, like I said in the beginning of this live, for YouTube that came down early summer, wanting the YouTube channel, the subscriber count, comments, all kinds of stuff. I'll have to pull that up and read it. But it was like a lot of information they were looking at. It's like, who the hell's YouTube channel are they looking at, though? Was it Kohberger's? Did he have a YouTube channel? If he did, what was he doing on it? Or was it a channel like this that talks about the Kohberger case? Because there was a lot being said back then. A lot of people coming into panels talking about a lot of different things in that case. I always was so curious about who that YouTube warrant was for. But it's mentioned here, but that's just part of your Google. I know that. So doesn't mean he actually had one. And then she's going to go through her case laws, citing different things that will support that for her. The court then found that the warrant failed. Let me go back up here just a little bit. A search warrant that includes broad categories of items to be seized may nevertheless be valid when the description is as specific as the circumstances and the nature of the activity under the investigative permit. The court then found that the warrant failed to test in two respects. First, it left to the discretion of the investigator in what was relevant to the crimes alleged. So just like when they're going to go into a home and search the home, they can't just go in there and broadly take whatever they want because it might be of interest. They have to kind of get really specific about it. And that's what she's saying here. They needed to be more specific with what they were searching for versus getting the entire account and looking through it to see what they could use out of it. That's the way it's sounding to me. So I was reading comments, guys. Man, I was sitting here the other night and I was scrolling. I don't know. I was on YouTube and she had a live going, and I never watched that chick's lives, never. And I noticed it was silent. So I thought my phone's turned down. So I turned it all the way up, and she's still just going 90 to nothing. Her hands were going, and she was doing all kinds of weird stuff. And I noticed chat was saying, "You're on mute. You're on mute." And I started laughing. I thought it was funny. It was like the whole entire show. I guess she didn't realize she was on mute the entire time. And then she's like, "Oh my God." It was so funny. I just laughed. For you sneaking around, taking pictures, you using fake Google searches, going on live. I got Richard Allen's Google searchers. They're right here. We're all laughing at her. Poor lady. I still can't get over that. Yeah. I've been eyeballing that case because I was around when that case first happened, the Menendez brothers, and I'm keeping an eye on what's been happening over there because I've watched documentaries over the years and different things with that case. It's a very interesting case, I'll say that. Again, in the conclusion of this one, Mr. Kohberger requests the court suppress all the evidence obtained in these 3 different search warrants for the Google, and we know why, because she's going to say that they were fruit of the poison tree. But also she wanted him to get very specific. They did a too broad of a search, basically, during these warrants, is what it sounds like she's also saying. Okay, here we go. DB. Let's see what this one says. Motion to suppress the pin, trap, and trace device. The motion and documents in support of the front. Let's go with the issues. Okay, we know that's all under seal and we can't read it. Mr. Kohberger has a privacy interest in his AT&T account. The affidavit submitted to support the application for the issued warrant recklessly intentionally omitted everything. Okay, a fax. Let's get on to the facts, lady. On December 23rd, Corporal Payne of the Moscow AT&T account for information regarding his phone's whereabouts between November 12th and November 14th, as well as messages, phone calls during the period. However, the affidavit and warrant went beyond the range. Oh, really? After the warrant was granted, law enforcement received information from AT&T. This new information included the affidavit for a new warrant sought for both account information as well as a pin trap for Mr. Kohberger's phone. The exhibit affidavit was, like the previous warrant signed by Payne, the basic facts Payne used to support the search were essentially the same, but with the following added. Cell tower records did not show Mr. Kohberger was in Moscow at the time of the murders. In law enforcement's experience, however, people committing crimes typically turn off their phones. Or you could have left it beside the bed and said, oops, I forgot it. That would have been the easiest thing to do. But hey, that's just me. I'm not going to turn it off, as y'all going to be knowing I turned my damn shit off. Lord. Cell tower records did not show Kohberger was in Moscow at the time of the murders. The new information received from the previous warrant, according to FBI special agents that specialize in the analysis of historical CSLI data, showed that on November 13th at 2:42 a.m., Kohberger's phone was utilizing cellular resources that provide coverage to his Pullman apartment. They support the idea that he left his apartment and went south. They support the phone being off. They supported at 4:48 that the phone is south of Moscow near Blaine, which is going out the countryway back toward his house, opposite the way he came in. The phone utilizes resources that make their way back to Pullman, coinciding with the white Elantra seen on some surveillance there, because it wasn't seen again until it was back into the Pullman area. A similar data showing occurs at approximately 9 a.m. with a trip into Moscow and returning at 9:32. That was the next morning. Kohberger has a privacy interest again, with the same standard stuff she's been saying. Here at stake are the records of a telephone account. The records the state sought included identifying information about the account owner and their devices, device purchase information, email addresses associated with the account, call detail records, including text messages, cell site information, historical location information, cloud data, timing advanced reports. The Fourth Amendment has generally refused to acknowledge a privacy interest in records held by a corporation about communications that they facilitate. And she's going to cite some case law about that. In this matter, Corporal Payne specified in his request that the purpose for gathering the information from the AT&T records was to aid in determining the location of the 8458, that's the last four digits, phone, and the white Elantra in efforts to determine whether the white Elantra is the same vehicle identified in surveillance videos. Let's see if it matches up. To the extent of that information was being gathered, for the government of the vehicle, for the movements, I said government, for the movement of both the Fourth Amendment and Article 1, Section 17. In the wake of Carpenter and the court's recognition of the abundant records maintained on everyone in modern society, it's questionable whether third-party doctrine is still good law. However, this court need not consider whether the Fourth Amendment needs updating, because Idaho already has recognized any expectation in privacy of whom we dial and the content text messages we send. Therefore, to collect the records law enforcement requested in this matter, it had to have a valid warrant. The affidavit submitted in support of the application for this search warrant recklessly and intentionally admitted material information. Let me see if she says anything else that we haven't heard her say yet. The search warrant fails to provide specific particularization of what law enforcement could search for. But I don't know if there's like a particular way to, if you're already narrowing down the days you want to look at, how much more narrowing down can you get right? Because you don't know what you're going to find within that 2-3 day period until you get in there and look. So I don't know how that's going to play out for her in the big scheme of things. The warrant for Kohberger's AT&T account lacks appropriate particularization. That could be found in the account. And again, they're going to go through all that. The account holder, certain information on the account, accounts maintenance, all call records, texts. That's typically what we would see when we look at a phone. So I don't know how this one will stick with that or not, because I don't know how much, like, could you say I'm looking for specific communication between person A and person B, that kind of thing. I mean, how, I don't know how that would be handled with the court. That'd be interesting to see. I'm trying to I don't know this judge or how he's going to rule on anything, so I just hope he's not like Gull. I didn't get that impression so far. Well, I've only seen him in one hearing, so. Now, this is the search warrant. This one was for Idaho. Let's see, because I think I skimmed through these two earlier. Yeah, this is the Idaho for the search for we read the one out of Pennsylvania earlier. It was listed right behind this one, but we'll do it again. This is the search warrant for Mr. Kohberger's persons, and she lists the issues where that was gotten under the IGG. Due to haphazard way in which law enforcement has kept and disclosed records in this matter, the following is the facts as best the defense can tell. On December 28th, Trooper Larry of Pennsylvania became aware of the objective to arrest Mr. Kohberger. On the 29th at 4:44, the magistrate in Pennsylvania issued the warrant, same as the language of the other documents. And she goes through that steps again of when they arrested him and when the SWAT came in. And her argument again is the recklessly and intentionally omitting materials. I'm looking for, again, any discrepancy between the items for which there was probable cause and their description in the search warrant. So she's basically got the same language for all of the motions that she's filing, trying to get them out based on the same stuff. Either they're too broad of a search or they were obtained by the IGG. So this is going to be on the Elantra. This one I didn't read yet earlier. Let me get a sip of my coffee. This is for the search warrant for the Hyundai Elantra. Now, we know they took that Elantra apart in Pennsylvania. Like, they took the doors off. They took the panels off. They took the brake pedals, the gas pedal. They took the car apart, and we're assuming they loaded it on a plane or something and flew it all back to Idaho in pieces, or to wherever their lab was that was going to pull the car apart and do all their work on it. And I still want to know what that shovel in the trunk, did it have any kind of soil on it? I need to know that. That's my jams. Or was it just for shoveling the ice? I don't live in those icy conditions, so I don't know. Pennsylvania search warrant for white Elantra, and it gives the tag number, or the VIN number rather, sorry. And again, she's going to explain the same issues as to why she doesn't think it should be allowed. Same thing again. On December 28th, the Trooper Larry, I wonder if he'd do an interview. They're not under a gag order in Pennsylvania. The court should apply Idaho's exclusionary rule and law to this search. I'm trying to get it sorry because we know that she has stated in court he had no known connection to the victims. This issue, however, has received some attention, and Professor Kerr argued his article in the Harvard Law Review that the jurisdiction where the crime occurred, she's going through the same thing again with all that. I don't feel like she's got any other reason for wanting the stuff suppressed, except that it was all based on the IGG. Not like, there's no other basis behind it yet. Mr. Kohberger argues that the Idaho Constitution exclusionary rule must apply. Again, they're going to have to show that they didn't obtain that IGG before. Idaho's going to have a problem on their hands with that IGG, I'm afraid. I'm afraid that people in past cases might have looked beyond it and said, whatever, we got the bad guy, but Ann's not buying it. What do you guys think? Do y'all think the IGG came first? No, you're right. It was not quite based on the IGG. Too broad of a search. I'm just looking at the comments here. Yeah, well, he was living in Washington, and we know it gets snowy over there, and in Idaho, I don't know, I don't know, so I don't live in those climates, but there was a shovel in the trunk. You carry an emergency shovel in the car? For what? I got a lot of stuff I can carry in the car, but I've never had well, we go camping a lot, so you could take a little shovel to put out little, your fires at the fire pit, but and if it does, I need to know if it's tied to a particular location. Let me just say it like that. And that's all I'm willing to say at this point. That's a whole other show. And then she's going to go through her list, and then the conclusion, the same thing, that it should be all suppressed because of the obtained by police via warrant that permitted them to search his car. As explained above, the warrant lacked probable cause as written, given its heavy reliance on conclusions reached by law enforcement without the details necessary for the magistrate to draw its own conclusion. And because the warrant omitted exculpatory information, and information that put into question the reliability of the facts upon which it relies. And finally, because the affidavit relied on evidence gained in violation of the Constitution. What exculpatory information? Bethany's out. That's nothing to do with Bethany. Let me go back up here for a second, because I think I did miss something right here. Without IGG, there is no case. No request for his phone records, surveillance of his parents' home, no DNA taken from the garbage out front, because the IGG analysis of the origin is the matter. Everything in the affidavit should be excised. Let me blow this up again. I cannot see. Joe, are you still having headset issues? I think he is. Mr. Kohberger has argued in a separate motion that genetic genealogy investigation in this matter was done in violation of the Constitution. Additionally, he has argued that there would be no investigation into him without that original constitutional violation. It is not that the results of the IGG sped up the investigation. Instead, they focused the investigation on Mr. Kohberger, a person whose only connection to the case was his mode of transportation and the shape of his eyebrows. Two identifications of little to no value, as previously argued. As the Idaho Supreme Court has explained, while the initial burden in showing a factual nexus between the illegality of the evidence, the state must show it would have been discovered anyway. Can the state not show that? The state cannot make this showing. Without IGG, there is no case, no request for his records. Okay, we read that part. because the IGG analysis of the origin in this matter, everything, she's wanting everything thrown out because she's convinced that IGG came down first. But everybody making the damn eyebrows. I don't know. There's a lot of things. Okay, so like everybody was saying with Rick Allen, there's nothing in his past. There's a couple of things in Kohberger's past. Now, Ann Taylor and certain people out here don't want us talking about him pre-trial because it might taint a jury pool. But why? We talk about all the other clients, all the other defendants, and all the other cases we cover, we talk about them. So I have a hard time not talking about him. But I have no facts, to say this guy's guilty or innocent of anything. I'm just saying there were a couple of things in his background legitimately that are there, not made up, that kind of will make you wonder about this guy, in his mentality and toward women and things like that. I don't know. But she's saying, because she's not coming out here telling you this isn't the guy who wasn't there. She did say that. But she's also telling you have all this stuff you've gathered, any evidence you do have on my client is out of here because of this IGG. The state's going to have to prove that IGG didn't come first. I wonder. And they're weird. I'm just going to say that. I've been on deep dive in this case for damn near 2 years, and I've seen all the TAPA talks. I've got a lot of them saved here on the computer and things like that. There's a lot of things he's done in the past that can not make him guilty, but just it's not like a pristine past. You know what I mean? There were a few things here and there. One of the earliest things, DB, was two of his former teachers from high school. And this is out there. This has been talked about, and the record has been shown, not the actual school record. He was enrolled in a program in high school, and this was a pretty big program where you were going to go into law enforcement. And he was removed from the program, and it had to do with the way he treated one of the females in the program, like the way he spoke to her, things of that nature. The two teachers that were involved, they would say things like that. That's what they were saying, that he he had to be the smartest guy in the room. And we saw that when he got pulled over by the female cop in Pullman. He was questioning everything to her. Like, is that normal for him? It very well could be, just his personality. But that was one of the first indications, was him getting removed from that program. When he got removed from the program, he was not happy about that at all. And then he didn't have any options but to go into the HVAC program like his daddy, which I think really irritated him. He really wanted to be in that law enforcement program. And then after that, he kind of did homeschool for a little while. And then there was a couple of things at the college level at DeSales, but nothing that got him into trouble. Now, he got into some trouble once he got to WSU. There's allegedly him and the professor had some problems. And he was on the verge of being fired from his teacher assistant's job, from what we are understanding. Now, there's a gag order in the case, so there's not a lot of people talking anymore. They were trying to talk in the beginning, but people didn't want to hear what they had to say, because it was all coming in. Don't talk bad about Kohberger. That's just people talking shit and people making up stuff. Like, we don't know any of these people, so how can we discredit any of them, But so there was some issues there that were looked into. Investigation at the college with him and that professor he had that he was an assistant for. Yeah, Danger, writing the weird stuff, well, if you go look at Stefan Stearns had some quite interesting Reddit posts, and so did Kohberger. So I don't know. We are prone to write weird things, but when you're that bright of a young man going into the fields you're going in, should you be out there being all goofy? I don't know. Yeah, we can't have the government violating rights to do anything. If you don't have, it's so hard to get away with any kind of crime these days. Murders, all these things. There's just too much DNA evidence, stuff that can be gotten, surveillance cameras everywhere, phone, but they have to not be able to just take these broad scopes and look at you. That you can't. There has to be rules in place, things like that. They have to follow the letter of the law, just like we do. They expect us to do it. We should expect them to do the same thing. And you don't get to just turn the other, look the other way because you got the bad guy. How do we know you really got the bad guy if we don't even know, can't trust your investigation? You sound like my sister there, girl. My mama had to go to the school all the time, it seemed like. No, from what we understand, it wasn't whatever went down, these teachers were talking about. It wasn't, they didn't go into a lot of detail. They kind of respected his privacy on that point, but it doesn't mean he did anything or didn't, but there's indications in his past that there were things. He just had problems with women. I'll just leave it at that. Even his sister has said that. I don't know the full details on it. And he was, he stole his sister's phone back in the day and all that. And his dad did call the cops on him, have him prosecuted because he was on drugs for a while and was doing all kinds of things that the parents didn't like, and they couldn't get a control on him, and things like that. So when he stole his sister's iPhone, Dad found out about it. Dad turned him in. Like, we've had enough of this, and so there's a few little things in the past, and I'm not saying that to say he's guilty. I'm just saying, like, there's nothing in Richard Allen's. There's only a few little things in this guy's past. Not all these guys are going to have horrible things hidden up in their past to be finding anyway. Yeah, he did an iPhone snatch. He stole sister's phone, where allegedly to sell it for some drug. He was on. So Brian Kohberger had an addiction to heroin, and he beat that. And he was also way overweight at some point. And I believe he had the gastric bypass surgery. And all people who knew him back then said the change in him was just incredible. That when he got slim, his confidence got different. He changed, things like that. DB. What? I was reading that. Okay, so that's the same thing with that one. That was the Elantra. And this is a memorandum in support of, let's see, let me get that up there. And this is again for the search warrant for and statements made. Interesting, because we know what he allegedly said. Let me get this a little bit bigger. The motion and documents in support. I'm not going to read that part. Okay. Submits the following memorandum in support of this contemptuously filed motion for an order suppressing all evidence gathered by law enforcement as a result of the entry into and search of Kohberger's parents' home in Albrights, Pennsylvania. Due to the haphazard way. Okay. Let me get down to the good stuff here. I don't want to read the same thing over and over. Again, with the Blaker and Mowry doing their thing. Next to the body of Mogan was okay, we already seen that. We know. Is she not going to give me any more than that? Was she already giving me? Come on, Ann. Same thing. They're all going to say the same exact thing, almost. Pennsylvania law enforcement violated Kohberger's Fourth Amendment right by entering and searching his parents' home without a valid local warrant. they didn't have a valid local warrant out of PA or just an FBI warrant because he had left and went across state lines. Oh Lord, she's about to pit the locals against the feds. She tried that earlier and with the other motion about this same about the Pennsylvania stuff. State warrants have no extra. I almost said extraterrestrial. I'm trying to get down to where she's got the really good stuff that we need to hear. She's citing case law. In this case, there is and can be no showing of the exigencies. Mr. Kohberger had been surveilled by the FBI for weeks. So they were following him from Pullman all the way over to Pennsylvania. So the 2 stops in Indiana were probably planned. Eye contact with our guy, make sure we got him. Where are y'all headed? To get Thai food? What the hell? You just left? I'm traveling to Pennsylvania. I'm just going to get Thai food. In this case, there is and can be no showing of the exigencies. Mr. Kohberger had been surveilled for weeks. At no point during this surveillance was he shown to have any weapons. There was no reason to take him inside the house. There was no reason to take him inside the house, as surveillance undoubtedly was aware of his daily runs. Or is she saying they should have arrested him when he was out jogging? Would that made her feel better? I'm confused by this one. The evidence the police sought was simply not the kind that giving him the chance to exit the I feel like I'm confused. Like, I don't understand. And you wanted him to wait till he was outside. Yeah, I get it. Not a dwelling, but they could break and run. You don't ever know who you're dealing with. You don't know how someone's going to react. You can't predict how that person's going to react that you're about to go in and make an arrest on. You just simply can't. So I don't know if there's a difference between arresting outside the home versus inside the home. Like, you got a better argument going with the IGG being bad and you don't, this warrant's no good because of that, versus inside, outside of the house. They can barricade themselves in the dwelling if they know that you're out there. Yeah, his parents were there. I don't think his sister was there at the time. She might have been, because we all wonder if she was it was like an informant. Because we heard that they allegedly went out and searched his car, the family did. Like, the police, alluded to that. Like, they could see them doing it. Like, why would y'all be out there doing that? Like, the sister got suspicious, they say. But that's hearsay. We don't know for sure. If you let the person get outside and go jogging, like, I understand getting them outside of their house, but if you do it while they're out jogging, then you put a bunch of people at risk at that point. If they don't know if you got a weapon on you or not. They don't know if you just put one in your underwear when you came out the front door. You know what I mean? There's a lot of leeway here with that. It's apples and oranges. Let's weigh it out. I come outside so I can arrest you, or sit out there and wait till he comes out the door. That's fine. But doing it while he was out jogging would have been just as dangerous as going into the house and risking other people. It wasn't like it was a no-knock warrant. They knocked first. I tell you, if somebody comes to my door and knock and it's the police, we need to come in and search. I'm like, hey, it's not me you're looking for. Let me come outside and y'all can have at it. I ain't getting hurt. Pennsylvania cases show that failure to announce in this case was egregious. So did they not announce themselves over there in Pennsylvania? You have to look that up. Yeah, they broke the door. They broke a couple of windows too, from what like at the garage area, there was a couple of windows damaged. I wonder if they offered to pay for the damage like they did with Rick Allen. Oh, we'll pay for the damage we did to your home. I mean, because if you're not the person they're gonna come in and tear up your whole house. When they did Rex Harmon's house, the wife says she couldn't even go back in there hardly and live, because it was like a hoarder house to start with, but they literally tear up everything. they'll just rummage through, throwing shit all around. They don't have no rhyme or reason. Yeah, I can agree with that. I mean, if we can't make exceptions on the rules for certain people. You take down all these people in the same exact way. You approach all warrants in the same exact way. You approach all homes in the same exact way. Now, sometimes you have to take special care with like a really horrible suspect, like, I don't know, like a top tier gang person or mafia or somebody really super, super dangerous, is probably packing, got people all around them and all that kind of thing. That's different level. But every, average Joe citizen out there being suspected of something, you can't just say, well, he's Brian Kohberger, which let's just wait outside till he comes out. So if you're going to make a change, you do it for all of them. That I don't like the special treatment. I don't want FBI cast over here in Idaho, but damn it, I wanted it in Delphi. No, I needed them both. I'm willing to hear it from both sides. I'm not going to play that good for one case and not the other. That's ridiculous. We've all been sitting there screaming, where's the FBI in Delphi? Where's the FBI? Well, they're all over the Kohberger case, all over it. And that's a problem for Ann. Mr. Kohberger has no criminal history, no reputation or violence, or even being a gun aficionado. It makes no sense that police were they got a couple of guns out of his house. And I'm guessing they weren't in the communal areas. It makes no sense that police were willing to announce themselves in Kitchener and not to him. They didn't announce themselves. Were they not wearing body cams when they approached that door? Taking the allegation in this case as true, there is still no explanation as to why a small army was required to capture Mr. Kohberger. Given the force of the police decided to use here, there was no reason whatsoever to break down the front door, shatter the basement sliding door, and point guns at the inhabitants. I don't know how I feel about that, Ann. I think that's kind of standard. I don't know about busting out all the windows and shit. What was the point of that? I don't know. The right of a man to retreat into his own home and therefore be free. Unreasonable governmental intrusions. I agree with that, but if they have a search warrant and they knock, because I don't like them no-knock warrants. I don't believe in they end up at the wrong house too many times. They've done it. Just boom, we're in there and gunfire erupts and oh shit, we're at the wrong house. You got to make sure. I'm catching up on the chat. Girl. This is true. Danger. Give the government a break, DB. So let's see what this last one. Well, let me finish this up here. She goes with the same standard language again with why she wants this one suppressed. Kohberger has argued in the separate motion. That's the same stuff. She's talking about his phone again, how that must be excised due to being gathered from an invalid warrant. Statements after arrest are either fruit of the poison tree. From what we know, he didn't talk except to say, I can't wait to be exonerated. Are we not wanting to hear that now? Unless he did say something we're not aware of. Any statements post-arrest of Mr. Kohberger are fruit of the poisonous tree from an unlawful arrest. In addition, statements made as soon as he was placed in zip ties and held at gunpoint by officers without Miranda warning should be suppressed. What did he say? To protect the Fifth Amendment privilege against compulsory self-incriminating, police must inform individuals of their right to remain silent, either to retain or appoint. Wait. This criminology dude knows his shit. Did they not read you Miranda right when they? What did you say to them, Kohberger? What could he have said that she wants kept out now? Because all we've heard that he said was, "I can't wait to be exonerated." Oh wait, he said, "Was anybody else arrested?" Didn't he? Isn't that what he was said? Danger that we were told he said. Has anybody else been arrested yet? I gotta go back and review some things. Yeah. Why would you want that suppressed, though? That mean there was somebody else there? He's just not telling us. Kohberger was zip-tied after a no-knock warrant was served. Hang on. Let me go back up here for a second. I want to read something. Tied after a no-neck warrant was served. He was zip-tied at his hands and surrounded by police at gunpoint. Law enforcement did not Mirandize him immediately. Instead, they waited until after he was transported in a police car, handcuffed, with at least 2 officers in the car. One was seated next to him in the back seat. See Frank 133, Idaho, blah, 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 blah. Defendant was in custody for purposes of Miranda when he was questioned while handcuffed and restricted to the area of the patrol car. Now, see, the restricted, that's the key word, because I was just looking at some exonerations in Indiana and overturned convictions on different things like this during a certain type of interrogation. If you feel like you can't get up and leave, that's a problem. Which I've got all that saved to do a show about it, but I didn't do it yet. There's some interesting things I found doing some research all night that the other night. 2 conversations took place before Kohberger was Mirandaized at the police station. Did I miss a part? A reasonable person in Kohberger's position would have understood himself to be in custody. 2 conversations took place before Kohberger was Mirandaized. It is clear from the police station video that detectives asked him if he had ever been Mirandized before, and they said they needed to go through the formality of Mirandizing him. He said no. No video or audio recording of the entry into the home. Oh, wow. An initial arrest has been produced. Video and audio began with Mr. Kohberger in the police car. Well, I don't like that at all. Are we seeing what yet, DB? Right? I mean, I doubt they lost. They just didn't do it, apparently. Yeah, it was Mr. Mullins in on this investigation somewhere, somehow. So this is Pennsylvania cops. Remember that, not Idaho, guys. So don't go attack the Idaho yet on this one. We can later on on the shit they did. So I guess in Pennsylvania they can do a no-knock warrant, and they didn't video going in. We've all wondered if they were ever going to release that body cam video. Do they have any of it? And things of that nature. So if they don't even record it, they sure should have. Like, I'd have been like on the phone with them. Y'all make sure your body cams are on. Make sure everything is done right. We know this is the guy. We don't want to do anything to mess it up. But yeah, Danger, 2 conversations. I wonder what those were about. In determining whether a person has been subjected to a custodial interrogation. Custodial interrogation is what we're talking about when we say you don't feel like you have the right to get up and leave. Like being placed in the back of the police station in a room, like Rick was being questioned, like Andrea described. You get up and walk away through the double doors and down the hall and to the left and to the right and out all those things. And I was looking up that just the other day with custodial interrogations, and what they actually meant and the law behind it. And if you feel like you just can't get up and walk away, you're in a custodial interrogation. Right, DB. So in determining whether a person has been subjected to a custodial interrogation for purposes of Miranda, courts may also consider the conduct of the officers and the nature and manner of the questioning. The conduct of law enforcement with Mr. Kohberger in the house is referred to as small talk when he is being recorded during transport. This cannot be verified because no audio or video was produced. The conduct of the officer in the police car during transport cannot be described as an interrogation. However, without a video or audio recording of in-custody discussions inside the house, the true nature of the statements made in the car without context. All statements made at the police station were post-Miranda. Information in the media right after arrest and attributed to law enforcement report that Mr. Kohberger redacted. Such a statement is not in a police report. We only know he said, I can't wait to be exonerated, according to his attorney that was in Pennsylvania that was assigned to him when he got arrested, that spoke with him just for about 15 minutes. And we also were told, or we had heard through the grapevine rumor type shit, that he allegedly said, was anybody else arrested during this small talk conversation? What's redacted here? Why can't I see that? I don't like the redactions. I'm going to start to hate redactions. I swear to God. Such a statement is not in a police report or an audio recording that can be found in discovery. So they alleging he made an incriminating statement. You can't prove it if you didn't record it. If it is a statement that the state will seek to attribute to him at trial, it should be suppressed as non-Mirandized statement. What did he say? If the conversation with Kohberger inside the house was custodial in nature, that context may warrant suppression. She may have a good argument with this one. Yeah, it's prejudicial. Rick should have been afforded. Yeah. Girl, I'm telling y'all, Kohberger was arrested a month after Richard Allen. And I've been watching both cases the entire time. This was happening with Idaho, the tunnels, the this, the that's, all these ridiculous theories that were out there. May not be ridiculous in the end, but they were at that moment. They were becoming so ridiculous. It was everything and their brother did this except Kohberger. And I'm steadily getting so bored and tired of hearing all that I'm watching everything going on in Rick Allen's case. And all I heard in Kohberger's case was his rights, his rights, his rights. And they were so heavily protected. But none of those people screaming that at me wanted to hear a damn thing about Richard Allen and his rights. And that was such a turnoff for me. Like, I didn't want nothing to do with Idaho at that point. I honestly didn't. I got so tired of it. You can't, that is so unfair to be over here screaming. And I get people get behind their one or two cases that they really follow and support, and that's great. But all of these defendants deserve the same across the board. And when I saw how well Kohberger was being treated as a defendant in Idaho and giving all the liberties that he has been given, including down to the suit and tie at hearings pre-trial, that's usually reserved for trial, not pre-trial. Poor Rick Allen couldn't even get a shower. I mean, it's like, golly, man. At least Kohberger is having all his personal rights protected while being in the jail, but Ann Taylor's fighting hard to make sure all of his rights were done, constitutionally. We knew she was going to take this angle a long time ago. We just didn't know when it was coming or how far it was going to go and how far would they let her go. And I'm so curious to see how this new judge ends up deciding some of this stuff. It's going to be hard. I mean, it wouldn't be too hard, but I'd be like based on the law and facts to back it up. Yeah, it was Judge was the judge before. Now, like I'm with Sleuthy on Judge. We liked him. We didn't see the problem with the judge. There was nothing. I know everybody has a problem. I don't want this to come out wrong. A lot of people who support Brian Kohberger in Idaho had a problem with everybody in the damn town. You know, if you lived there, if you worked there, if you went to school there, if you taught school there, you're all in cahoots and in connection with something. But are they really, Detroit was, there's no way. I watched all the hearings. I've watched every single hearing ever happen because we got cameras all up in the Idaho case. No. I mean, the judge has never done one thing like Gull has done. Not one time. There was one time there was a hearing asked for, and he went ahead and made a ruling. But when you watch the hearing that they had about that, you see how good his argument actually was and how Ann also agreed with him on his argument, the judge. So, no, you got to choose. The judge, Ann stated in her last hearing on the death penalty that Idaho forced Kohberger to choose between the speedy trial and effective counsel. Because if we go with speedy trial, I can't be effective counsel. Well, my dear, that's an Idaho Supreme Court decision. As far as y'all's laws are concerned about what's speedy trial and what isn't. But that was the basis of that. Was what she said in court just the other day. I watched that entire hearing. Well, Joe, try to talk to me and see if you got your headset figured out. Yeah, unfortunately, no. The judge over here where they've transferred to an Ada County, they're used to hire, well, they had Chad Daybell and they had Lori Vallow. They had two back-to-back high-profile cases. It's a much bigger place. And that kind of thing. Judge has now come out, the former judge in Idaho, has come out and he's retiring now. Did that play a part in it? Did he finally just say, you know what, I'm going to move the trial anyway because I'm going to grant your change of venue, which I agree with, he should have, or at least brought a jury in, because let's be honest, changing these trials to another venue is hard on families. And at some point, I'm going to step up for victims, because I'm all about defendants' rights, but I am 1,000% for victims' rights as well. And if my child was murdered, and then I found out I got to travel 400 miles just to get to court, I'm not going to be happy about it. And then if I go set up a GoFundMe to help get me there, are people on the internet going to come attack me for doing that? Like, it's all a case by case thing. You know what I mean? We can't just go after. It's a hard thing to decide. But I don't know how this judge is going to be, if he's going to be fair. Some of us began to feel like Judge was being way too fair. Like, he didn't want to get in trouble, and he wants to make the right decision. He doesn't want to give Ann Taylor everything she needs to come back on appeal because he made a wrong decision, kind of thing. So, hey, did I lose you guys? No. Yeah, I don't mean putting them. Everybody has stopped talking about these victims. When they were talking about these particular 4 victims, that was blaming the victims. I don't know how much everybody's been around the Idaho case, but there's been a lot of victim blaming in this case. All kinds of scenarios that came out of nowhere, Yeah, I know, girl. I know. Yeah, I don't. Yeah, I just mean at some point the victims do matter, and they have to be stepped up for as well. But I don't think it should overshadow what. Like, you can't just come in there and bring in, look at these victims and this guy, and make it like that. But it's a balance. It's got to be a balance between it all. Yeah, is what I mean, basically. Yeah, I mean, there's been all kinds of blaming in this case, But and I'll be honest, for a long time, I couldn't even talk about this case with a lot of people, because if I didn't agree with them that he just wasn't the guy, then they didn't want to hear anything I had to say. And I was attacked for it. I mean, literally attacked. And again, WSU Mom Kim, if you're out there listening, I'm still down for a conversation, honey. Any damn time you're ready. I have to get that off my chest every now and then. Cotton Eye Joe, she ain't far, I'm sure. What kind of questions you got? We might have answers, but we might not. There were a lot of filings that came out, let's see, over the past couple of weeks, and a lot of them were due to suppressing the death penalty, which may be a little too soon, but what are you going to do? Now, these are new ones here. This motion for leave, I spoke about it earlier. They wanted extension on some, the defense wanted extension for some discovery, and they were denied, which was like the first time they've been denied anything in a long, long time. I'll be honest. They have not been denied across the board. They're given everything. Nobody can come back right now and say they're not doing anything in Idaho 4 to help the defense. You know, there's a lot of talk about the discovery motions and how many discovery motions have been filed, but I beg you to go look at Chad Daybell's case file, which is also right here on this Idaho page. You'll see how many were filed in that case alone, just on discovery. And we have to remember, in Lori Vallow's case, they took the death penalty off the table because they sanctioned the prosecution for failure to turn over discovery in time. Idaho don't play around with that. I don't think they're going to be able to get away with that kind of stuff that we saw Indiana getting away with. You know what I mean? Just from watching the other two cases I spoke about and all the things I saw go on there, I have no doubt that they're going to do it right in Idaho. Did they do their search warrants right and their IGG stuff? I don't know. All that remains to be seen. But as far as the judge making good decisions and granting motions and hearing them out, I think that'll happen. But the thing with the Ann and Jay, you have to keep an eye on is when they start citing case law, sometimes they want to go back so far that doesn't even pertain to what they're talking about today. And you just have to go, wait a minute. And this judge actually started talking to Ann about that in the last hearing. And she, like Joe was saying in the beginning, she would say, okay, well, yeah, you're right, Judge. She agrees with them on a lot of things. So, you know, just with this case, it's still 50-50. I don't know if this guy did it or not. I'm not here to figure it out. I'm just here to read the case files and see what Ann brings us. If I can get really get behind any of it. And from what I'm reading so far, they better hope to hell that IGG is not how they got to their client, because that's not going to fly. The discovery that Ann continued to ask for, most of it was what the FBI had. So and we have learned you have to fill out, there's documentation to get that stuff from the FBI. Will the FBI even hand it over? A lot of times they don't. They don't have to. It all depends on what it is and what they really want to give you. There was another, let's see, one that came down, because honestly, there shouldn't be that much left for the state investigation to have left to give these people. Because if they did their investigation, they know this is the guy, they should have all their evidence. Now, Ann has told us how many terabytes they gave her, all this work she had to do. And the judge reminded her again the other day, honey, you're a long time from trial. Get busy. She's going to stand there in court and tell us all this work she has to do and all this discovery she has to go through. But yet people are out here thinking we don't have discovery in this case. She's got a ton of discovery in this case already. Let me pull this up real quick. I mean, to say they haven't been receiving discovery is a little not fair, because she continues to say in court how much she's still got to do because of all the discovery she's gotten. So either you have or you haven't. It's one or the other. It's not, you have to listen to these when they're talking in the hearings, especially Ann. This one it refers to the 18th supplementary request for discovery. Please take notice that the undersigned, pursuant to Rule 16, the Idaho Criminal Rule, this is asking for discovery and inspection of all materials discoverable by. Now, see, we don't know what this particular 18th one is about, which it's going to be Exhibit O. Now, is Exhibit O something the FBI worked on? Again, if it is, that's what she's doing. She's still trying to get their information. I don't know what all she received in that last subpoena she gave to the FBI. And like Ann Taylor has taken on the FBI. So any discovery out there, she's asked for a lot of discovery, and she's received a lot of discovery, but not all of it's come right out of the Idaho Police Department, the Moscow Police Department. I don't think she's a drama queen. I just think she's going to do her due diligence to her client. And if there's any, because think about it, not all defendants are innocent. So if you got a client that's factually guilty or actually is guilty, the best defense you can give them is, was the search warrant obtained legally? Were you looked at and found legally? Was it IGG that brought, all these things do matter. Even if he is the guy, it still matters going forward. And if you follow enough cases, you'll see a lot of the stuff she's filed early on were just a lot of normal defense filings. Now, I know Andrea will probably have a lot to say about these filings because she's done like a lot of videos on them. I'll be honest, I don't really watch her Idaho 4 content, so I really don't know where she stands with a lot of it over, the past few months, because I've been watching Delphi for a long time. So be interesting to see what her take is. Bob really doesn't talk about the Idaho 4 case a lot. He did in the beginning. People was going to him all the time, all these problems in this case. And Bob's like, yeah, I just don't see it. And I never did really either. It's quite standard stuff. So we'll see. She's got all those motions to take out the death penalty. And some of her arguments were in the hearing that she just did, because there's like 5 different ways she's trying to go after the death penalty. But some of it made sense, some of it didn't. It's just she's got to do what she's got to do to try to get everything peeled back and away. So if he is guilty or found guilty, less sentencing, things like that could happen. There's all kind of different ways they could look at it. To get the information from the feds, you got to fill out your TUI report first, and then you got to get your FBI subpoenas, which she did have 2. The judge told her that day in court, you get me those subpoenas, I'll sign them by the end of the day. She said done. And we've not heard anything else about it. So I'm assuming she got what she was after, because she wasn't going to give up until she did. That's crazy, but she did. Joe, are you still with us? I think Joe dropped out. He was having a little bit of technical issues a little earlier. Yeah, it's going to be interesting to see how this plays out for her. I'll keep an eye on the docket too, and we'll know when the next court date comes up. Hopefully he'll decide by the beginning of the week if he's going to even give her the Frank's hearing. If he can hold. When he reads that Frank's motion that she's got that we can't see, if he agrees with what it says in there, I wonder if he'll just go ahead and grant her the hearing to hear her out then, if they'll make it a closed hearing, or if they'll leave it open. They have only had, I think, like 2 closed hearings in Idaho, and both times it was because IGG stuff was being discussed and some grand jury stuff. And like they immediately, though, the second the part was over, they opened up that there has not been any hidden hearings over here in Idaho. And we got cameras, we got audio, we got all the things to keep a really good eye on what's going on. So well, Kaylee's dad supports the DP, and that's why they live there. I'm in Florida, lifelong resident. We've always had the death penalty. I don't have a problem with it personally. I do not get into DP. I don't argue that debate at all. It's a personal thing for everybody, but for me, it doesn't bother me. If you did it, that's not. If it was my fight, I'd take it up. But I don't really talk about their parents a lot because there's been a lot said about the parents in this case. Way too much said in some some cases. And did Steve cause a lot of it and bring it on himself? Sure, but I'm just not in the mood to go after parents over on this Idaho Fort thing. I'm just really not. Who said they left that tip line open for a year after that? She's gotten. Maybe I should play back some of the old hearings because you guys can find them. They're on YouTube. Listen to what Ann says in court. Don't listen to what everybody else out in the world has to say. Of course, we can all sit here and talk about it, but when they're in court, I am very much paying attention to everything Ann Taylor says because that's when she tells me facts on this case because of a gag order. It was in a hearing that you said that she said that. Well, she mentioned the tip line, but that was part of all the information she was listing out that she had to go through. All of it. I mean, she was trying to give a laundry list of stuff, but like the judge is just sitting there. We heard the same thing in Delphi. A lot of discovery. We got to take the time to go through it and make sense of it. You don't give us it's not coming in order. It's all not laid out in a neat little package. So there's a lot to go through, yeah, but that tip line's not going to help her much with her criminal case, I don't think. Not as much as, IGG came first and these warrants are invalid. Nothing that hit that tip line is going to help her get her client off unless she's willing to go out and try to find the real killers. Only reason they were brought up in Delphi is because the police actually investigated them. We know there was some people looked at early in this case and ruled out. Well, they got a cigarette butt from somebody and matched, ran DNA on that. They weren't just looking at Brian Kohberger, and then they didn't even know who he was for a hot minute. They were just looking at anybody closest to the victims. So she's got a lot of discovery. I don't know if they need to get a better system with giving each other discovery. You know what I mean? Like list it all out, put it in really neat little folders and files. Well, here's what we got here. I'd be like, could y'all please do that? Because I think they should, especially if we're going to start hearing these attorneys come into court cases talking about all these terabytes of discovery and all the time it takes to go through it. Well, then we need to work on that. We need to figure a better system out. Well, beyond fire, I can also say that Steve G's not the only one out there spreading made-up fake rumors. I've heard a lot of the things that Steve G has said, but more disgusting are the rumors that people on YouTube have made up, if you ask me. Thought they were supposed to like a neat little package of discovery. It would be great if they did. I think it would help a lot of defense attorneys because it probably is very time consuming to go through. Can you imagine how much video footage you got to watch? Like I said, the Linda Lane footage. If you got that and you don't really know that 4 a.m. was the time yet you should be looking for, you got to sit there for hours and hours watching all that. And we know, well, most of us know how many times that damn footage was viewed on YouTube and analyzed. Yeah, YouTube was far more disgusting, wasn't it, Danger? We've seen it all. Heard way too much. But, guys, I'm going to wrap it up. It's been like 3.5 hours, and I need to go get something to drink, and I'm kind of getting hungry a little bit. Yeah, he does seem very active. I mean, the guy is not dumb. He's very smart. He's, got these PhDs, criminology, criminal justice, all the things. He knows what he's talking about. And you can see Brian Kohberger watch his attorney intently when she's talking and making her arguments. I pay attention to him. Like I'm watching him to see his reaction. And he is just like, watching everything she's doing. Yeah, I'm gonna have a show and we're gonna look at that Linda Lane footage some. There's people who haven't seen that yet, if y'all can believe it. Thank you, Danger, for coming in. I gotta get with you soon. I'm gonna get you up here with me one night. I know your schedule's a little crazy, but all right, guys, I'm going to wrap it up for tonight, but thanks for coming in. We'll do a little more deep dives into, I want to actually go back and look at some of the earlier warrants and compare to some of this stuff and look at the IGG stuff some more. And, yeah, right. Danger. You found my professor in Delphi long before anybody else did. I still can't get over that. We should have had you come into court and testify to that, right? Like, get my friend Danger in here. He found Turco, whatever his name was. All right, guys. Well, thanks for coming in, everyone. I appreciate it. I really do. And I'm really bad about saying this and or forgetting to say it. But if you don't mind, hit the like and subscribe. That's important to the channel to grow, and I do appreciate it. And again, thanks for coming in, and we'll take another deep dive another night into some of these. I do have a show in the works because there's somebody I've been talking to earlier, and they kind of want to go back to the beginning a little bit, just to kind of get at the backstory on to really, like, starting with the PCA. There's just a lot, the people who are maybe new eyes coming into the case, and there's been so much out there about it. Like, I just try to stick to what's in these documents coming out in here. So that's what we'll do. All right, guys. Thanks a lot, Butterfly. Y'all have a great night. I'll see you again soon.